Good morning, everyone. I'm just going to wait a couple of moments before opening today's programme, simply to allow everybody to join. Sometimes it just takes a little while on the technical side, and I can see the number of participants going up and up, so hopefully we'll have a great turnout. For those of you just joining, I'll just repeat what I said earlier, which is good. Well, I would say good morning, but actually it's afternoon now, of course, at 12:01. I'm just going to give it a couple of minutes because the number of attendees is still increasing. And sometimes, as I say, it takes a little while for everybody to come online and to actually join the seminar. Again, I'll just give it another minute or so because people are still joining. The awkward silence before we begin. Okay, I think the numbers are stabilizing now. So perhaps if we can begin then, and may I first welcome you all on behalf of both the Bar Human Rights Committee of England Wales, otherwise known as BHRC, and our partners at the from the Young Lawyers Committee at the Human Rights Lawyers Association. And we're absolutely delighted to be hosting this virtual seminar today for you, and which of course is all about skills for human rights practice. We very much consider this seminar to be a core part of BHRC's education and training advocacy programme this year. And in many respects, that affirms our commitment to inspiring and supporting the next generation of human rights defenders, of which we hope many of you will become if you're not already. And we've got an outstanding programme, in my view, prepared for you today. We've got a stellar lineup. We've got speakers who are barristers, solicitors, human rights defenders, educators, NGO leaders, and all of us here today share a very keen sense of wanting to share our journeys and our learnings along the way in the hope that they might inspire you all to consider a career in human rights, and hopefully you can learn from our mistakes, in short. The programme of panel sessions, similarly, has been designed to help you explore the different types of skills you might need to develop to engage with human rights practice in the future, to pursue whatever human rights specialisms that may be that you're interested in, but also to understand the realities of working day to day on serious human rights issues. It's certainly not a glamorous world. Let me make that clear from the outset, but I very much suspect that any of you that have joined today already know that. I'm very pleased to introduce the speakers joining us for today's opening session. Firstly, Kirsty. Kirsty Brimlow, King's Counsel, is currently the Vice Chair-elect of the Bar Council. She's the former head of the International Human Rights Team at Doughty Street Chambers, And she is, perhaps most importantly for this session, a former chair of BHRC, and continues to assist in terms of sitting on our advisory board. And alongside that, we also have Jo Middleton, King's Counsel, Chair of the Human Rights Lawyers Association, and we're going to be co-chairing this today, jointly between the three of us. I'm Joanne Cecil, I'm a barrister at Garden Court Chambers, and I'm the Vice Chair of BHRC. And so basically, welcome to you all. I'm going to hand over now to Jo. It's two Joes and Kirsty, she says, who's going to say a few words of welcome on behalf of the HRLA before we jump into our discussion this afternoon. Thank you. Thanks, Jo.
Thanks very much, Jo. For older attendees, you might be thinking of the two Ronnies and how we can make jokes about each other, but let's see if that happens. Very warm welcome and good afternoon from me. As Jo says, I'm the chair of the Human Rights Lawyers Association. I'm really pleased to be co-introducing and co-hosting this fantastic program designed and organised by Louise Loader. Enormous thanks to her for doing that. So I thought it might be helpful if I started off by saying a bit more about the HRLA for those of you who are not familiar with the organisation, and then perhaps Jo could say something a bit more about the work of the BHRC and indeed Kirsty and/or Kirsty. So HRLA, BHRC, I was thinking of the distinction between them reminded me of what the founder of the Methodist Church is supposed to have said about his church and the Catholic Church, which was then and is now the biggest church in the world, that the Catholic Church was a church for all good Christians, but that his new church, the Methodist Church, would be a good church for all Christians. And so my clumsily made point is that the HRLA is a somewhat broader organisation than the BHRC. Because our membership covers human rights lawyers across the spectrum, from law students and trainees to pupils, solicitors, barristers, even some members of the judiciary, also legal academics and lawyers at NGOs. And our honorary president is the distinguished jurist and Lord Justice of Peel, Suribinder Singh. The HRLA was founded 21 years ago now by our late and much missed colleague Jonathan Cooper and others. And today we've got about 2,000 members, and our very broad aim is to protect and promote human rights by increasing knowledge and understanding of human rights. The mainstay of our activities is organising seminars and other events on topical human rights issues, and in doing that we strive to be apolitical and non-partisan. Recent events that we've had included a fantastic seminar on climate change litigation with Lord Carnwath and Jessica Seymour, King's Counsel, and another recent event we had on sanctions and the human rights implications of sanctions designation. So two examples of the kind of activities that we've done, very topical and really very interesting sessions. We have used to be called Young Lawyers Committee. They've recently recast themselves as the Junior Lawyers Committee, and they are running their own excellent program of events during the year. That includes an annual careers day for aspiring human rights lawyers, a judicial review moot competition, and the annual Lord Kerr essay competition on a topical human rights issue. We're also very pleased to have an annual bursary scheme which allows junior lawyers with an interest in human rights law to spend a few weeks with one of our partners doing human rights related work, and our partners include Justice and Liberty. And so while I'm talking about the organisation, let me finish before I hand it back to Jo with the inevitable recruitment plug. If you're attending this event and you're not already a member, do please consider joining us. We would be delighted to have you within the organisation, and details are of course on our website. So Jo, I don't know if you'd like to say a bit more about the BHRC now.
Yes, thanks, Jo. Well, I'm going to do a similar plug actually. Then I'm going to pick up where you left off, and similarly, we would greatly welcome individuals to become members. I'll tell you a little bit about us in a moment, but effectively members of the Bar Human Rights Committee are either barristers called to the Bar of England and Wales, pupils, legal academics or law students. And so it's a broad church. It's not as broad as HRLA, it's got to be said. It's obviously set up predominantly as to well, it was set up to fill the vacuum actually within the bar for human rights work and human rights organisation and representation. And perhaps that brings me nicely onto a little bit about us. It was founded in 1991. It was founded by the former chairman of the Bar Council of England and Wales, Anthony Scrivener, Queen's Counsel as he would have been then. And its structure was first approved by the subsequent chairman of the bar, Gareth Williams, Queen's Counsel again, otherwise known as the late Lord Williams of Mostyn. And as I say, BHRC was set up to fill that vacuum. There wasn't an organisation within the bar dedicated to human rights. Its original core aims have continued throughout its existence. They are to support judges, lawyers, human rights defenders, individuals who are persecuted or prevented from effectively protecting the rule of law. And since its foundation, I should make it very clear, however, that BHRC has become autonomous of the Bar Council, and as a consequence, and over the years, has also extended and quite extensively the scope of its activities and its membership. As I say, initially it would have just simply been barristers at the BHRC. In terms of a little bit about what we do at the Bar Human Rights Committee, it works predominantly, as I say, to promote the rule of law and protect human rights around the world. Again, that's in all jurisdictions, but importantly, and again, perhaps slightly differently, it does not apply to the UK. So BHRC is not concerned with human rights in the United Kingdom. It is very much an organisation that is set up looking externally across the world in that regard. In addition to that, it also works, as I say, to promote protection of human rights defenders, of judges, of lawyers, the integrity, the independence of the judiciary, the integrity and independence of those legal professions working within the justice systems. And that's been a very much long-standing theme, and that is buttressed and supported in very many different activities. Some of those involve trial observations. We've recently held or launched a report into trial observations undertaken in Palestine in the military courts there. Other countries involve Turkey, Egypt, a whole host of different places across the regions. But BHRC also reports in terms of aspects of the rule of law. It might be freedom of expression, of assembly. It has very recently worked quite extensively on Hong Kong and China in that respect. It also undertakes interventions in significant cases in different court jurisdictions, for example, the US Supreme Court, other African jurisdictions, and indeed the regional human rights mechanisms. A fundamental aspect of what BHRC does, and to some extent this today really sort of comes into that, is training and education. And so often members of BHRC are involved in training lawyers or judges or human rights defenders or journalists overseas. And that can be a whole range of activities. It may be quite technical in terms of the legal arguments. Alternatively, it may be in relation to advocacy, for example. So there are lots of different ways, or even in terms of how in terms of upskilling, and that's quite a significant part, individuals within those countries to undertake trial observations, for example, themselves. So that's a broad overview of what we do. In terms of the areas of in which we work, effectively, if it's human rights, then we typically have some level of history in terms of involvement. It may span from children, juvenile justice, criminal justice, environmental issues, as Joe's already alluded to, all the way across the board, and again in all sorts of different countries. And so I hope that gives you a sort of brief introduction in relation to BHRC. It's a fantastic organisation, as is the HRLA, to be involved in. You get a lot back out of it, in short. It's a lot of work, but you get a lot out of it as well. It's fascinating, and it's a real privilege, frankly, to be involved in that way. I don't know whether Kirsty, you wanted to add anything to that, because obviously Kirsty has huge amount of experience, many years of experience within BHRC. She's been there for as long as I have, which is well, certainly I've been there for more than the years than I want to count. It's over a decade. I don't want to think about it. And Kirsty was chair for part of that period as well. And really very instrumental in ensuring the stability of the organisation moving forwards and really setting up for the work we do now. So I don't know if Kirsty, there's anything you wanted to add?
Yeah, other than to underline that it's just a brilliant organisation. I mean, I was on the executive and then vice chair and then chair for around 15 years. I was chair for 6 years. And in that time, sometimes I wonder why I gave so much of my life to the Bar Human Rights Committee. And a big part of it is that there's a wonderful executive, you included obviously on that, Joe. And a lot of those people who were on it many years ago have remained on it, have carried on. Every time there's an election, they'll re-stand for an election. And part of the reason for that, I think, is the variety of work. There's a lot of flexibility in terms of areas of human rights where a particular barrister or student or junior, particularly very junior barristers are interested. And then there's a variety of mechanisms that can be used, which quite often haven't been used because people haven't had the time, they haven't had the resources. And sometimes it only takes, I think what I always liked about BHRC, it only takes a small number of people to actually impact and make a positive difference. And we had many examples of people released from custody, being political prisoners. We had many examples of trainings where the result of the training was tangible. A new court had been set up, a case had gone through finally to prosecution, which in a sexual offence, which had never ever happened to get before. And we also had many examples of change with communication, sometimes almost brokering communication between states, and we were able to come in there as an apolitical organisation and sometimes perhaps fill some of that charged communication gap. So do join. is my final point on that. But Joe, would you like me to talk a little bit more specifically about, maybe just weave in a few concrete examples of those? Should I do that? So, as to perhaps why I ended up at BHRC and why I ended up in human rights practice, I probably, reflecting, I probably always worked in some way for the vulnerable. I mean, when I was a child, I would be there petitioning to stop the clubbing of seal cubs and petitioning to stop the harpooning of whales. And I suppose as I grew older, as a kid, I thought, well, I can't do much to help the humans. I could see lots of disasters around me, and tried my best for the animals. And probably as I grew older at university, I started to transfer that want to try and help those in a lesser privileged position than me. And at university, therefore, I was part of fundraising and then taking inner city kids from deprived backgrounds on holiday. And I was at Birmingham University and we took these kids away. And that sort of thing started to have a real impact on me. And when I came to the bar, I very much barreled into bar politics, taking on the representing the junior bar. There wasn't then a formal young bar committee, and I was really taking on different causes then, including the terrible legal aid rates, particularly for those working in crime. And the human rights work never went away, and it also stitched in with a love of traveling, a real love of exploring different cultures, learning from different cultures. And just fast forwarding a little, probably my connection with BHRC was 2006 specifically, in that I went to work on death row cases in Jamaica for 2 months. And that was an experience of working with local lawyers, at learning from local lawyers and actually just getting some of these cases where people have been forgotten. We had all sorts of people in the prison in Spanish Town who had mental health issues, had been there for years and years, and some had forgotten almost why they were there. And from that, I wrote my first article for the Times newspaper on Jamaica and on the death row system there. And that led to really a partnership with the Times in writing, which has continued until this day. At Bar Human Rights Committee, I then became more and more involved. And when I came in as vice chair and chair, I set up trainings in partnership with UNICEF in Nigeria. And that developed into partnership with the Nigerian Bar Association. And the trainings themselves resulted in around 15 visits to Nigeria. I think Joe knows that, Joe Cecil knows that I've actually got a Nigerian name. I was there so often. And that was all on child rights. And we saw tangible changes to the court process and in the change of treatment of children within the court system, because it involved training the judges and then training the National Institute that trained the judges. So it just built and built and built. And I think that's one thing really from seeds you do. It's a bit of a cliche, but you really do get an oak tree out of these different seeds. In terms of the other thing with human rights is I think often it does overlap with diplomacy. And there's different types of advocacy within human rights law, as well as the written advocacy. And sometimes you're using much more of a soft edge to the implementation of international human rights because you're dealing with states. And there's a couple of examples where BHRC was involved, and I was there in Bahrain, and there was over 20 political prisoners. And it was really meetings there in Bahrain, which certainly led to the release of those political prisoners a couple of weeks later. Undoubtedly, it was also linked to the timing of Formula One coming to Bahrain. So it's quite often a combination of circumstances and timing. On that diplomacy, I think one area I was really proud of, and I remain proud of, is work in Colombia. And that was mediation between the Colombian state and a community of cacao farmers in Urabá in Colombia. And they, very briefly, they're called San Jose de Apartador Comunidad de Paz, and they're a peace community. And instead of being pulled into the conflict and being pulled on one side or the other, they refused to be displaced, and they set up their own rules, which included no alcohol, no firearms, no giving information to either side, but no displacement. We are remaining as cacao farmers. And they suffered greatly with massacres being committed against them. I came in mediating and negotiating an apology from then President Santos to the community for the past massacres. And I'd just like to finish what I'm saying by reading what President Santos said when we got to the apology. But before I do, I'd like to also point on Bar Human Rights Committee work and international work, just another couple of points on what you can achieve policy-wise. Through the work started at BHRC in 2021, finally, I and others managed to get through a UN resolution which condemns harmful practices relating to accusations of witchcraft and ritual attacks. That work started at BHRC. It's historic. During BHRC time, a group of us changed the law on FGM, in that we recommended the introduction of FGM protection orders. There was some resistance from activists who wanted more of a focus on crime, and when they came through, they have been incredibly successful and supported by activists. So you can make a real difference on policy, on law, as well as observations, pressurizing, raising awareness, and obviously on the cases themselves, on using litigation. But if I may, I'm going to end with what President Santos said to San Jose de Apartador peace community. The massacre that they'd suffered was on the 21st of February 2005. And it was when paramilitaries and the Colombian army collaborated to kill the community's leader and 7 others, including 3 others, and three children. And they were macheted to death in a very remote part, which I have visited. It took a couple of days trekking on a mule, and the apology that was made had come from a constitutional court order in 2012 that hadn't been implemented. And on the 29th of November 2013, President Santos said this. He apologized to the peace community. And he said, "We do not agree with phrases or attitudes which stigmatize those who strive for peace and reject violence. On the contrary, we consider that every defender of peace and human rights must be praised and protected. For this, we ask for forgiveness. I ask for forgiveness. And I do so with the knowledge that forgiveness is a condition of peace, and that peace is the only guarantor that there will be no more victims." Thank you, Joe.
Thank you very much, Kirsty. That was really wonderful to hear. Joe, we've got just a little bit of time. Did you want to share a few thoughts on your journey as a human rights lawyer?
I'm more than happy to. I've just noticed, though, that we've got one question in the box, so I was just going to go to that instead for the moment. The first question was, what was the most difficult thing you've had to overcome and tackle? So I might bounce that back to one of you. I don't know if, Joe, you want to deal with that first of all? And
Well,
then
Kirsty is a much quicker thinker than me, so she probably has a better answer.
What do you think was the hardest thing, Kirsty? I mean, there are obviously and we're going to move on to this later in terms of the day, but obviously one aspect is about resilience and the emotional toll that a lot of these cases can take. I mean, you've spoken about death penalty, you've spoken about murder. I mean, those are sadly frequently seen in terms of the work that we're doing, whether it's torture, whether it's human rights violations or war crimes. Is there any specific thing that you wanted to tell us about?
There's a lot of examples, and to as you pointed out, Joe, I mean, to pick a single one is actually quite hard, because none of it is very easy, and there's points when you almost wonder whether you can keep going. With Colombia, with that peace negotiation, there was a time when I was sitting around in the community, and I was talking to them about the apology. Now, the continuation of this story is the apology was made, and this community had never expected to get an apology. It had been stigmatized as being FARC. The former president Uribe had in some way gone across the media to accuse them of helping the FARC, and therefore trying to say that it was in some way justifying extrajudicial killings. And so when the apology came through, a little like in a Hollywood film, I thought the community would, well done, Kirsty, and everything on this negotiation. But no, they rejected it. They said, we don't accept what's being said. They rejected different aspects about that there'd been problems with setting up the meetings, and eventually the apology was given from Bogota. And there was objections to them that it was from Bogota and various other things. And I just found it very difficult, because I didn't want to lose all this progress, and there was ongoing mediations, obviously, over actually investigating the killings themselves and other killings. And it was back and forth with lots and lots of emotions, and also my Spanish is not bad, but you're also dealing with very people who are really, really hurt, distressed, in grief, and very very long held trauma. And I think that was very, very difficult. They did eventually accept the apology, and they publicly accepted it, but it took a good 9 months of work. And I found, I think sometimes it's hard to keep the grief outside yourself. You feel the trauma probably more than if you're remaining independent in this on a negotiation. You feel the trauma more than you probably should, and that becomes lots of pressure. I think the only other thing, Joe, that you will remember was back in 2015, around then, it was a very difficult time with an open letter that we had written in relation to Operation Protective Edge, which was the firing of missiles from Israel into Gaza. There then was lots of pressure placed on us. I received really horrendous emails, including death threats. And I was also traveling to Colombia at the time. And I remember all of us together were writing a piece in The Guardian to reply to another piece in The Guardian. And it was a pure legal letter that we'd written dealing with jurisdiction of the ICC. And there was nothing outside the law of that letter, which interestingly enough is obviously is going to be coming around again. But it's very hard to receive those kind of emails. And unfortunately, whenever there's anything over Israel and Palestine, the death threats would come through.
I'm just acutely aware of the time, and we're slipping now into the next session. There are a large number of questions within the chat, some of which actually we will be dealing with as the day goes on. And so I propose to deal with those as certainly in terms of the skills and experiences when you're starting out in the next session, and practical experience, those sorts of issues. I think, Kirsty, you've dealt with some of the hostility you may receive, and you can receive significant hostility. And certainly, Joe, I suspect the same is true of HRLA. That can cause all sorts of practical consequences as well, such as visa refusals, arriving into countries and being kicked out. All of those sort of longer term consequences as well. But as Kirsty said, an awful lot of it is about politics, and a lot of it is about negotiation. And you ultimately cannot divorce the two when you're talking about international law and human rights. So an awful lot of it effectively comes down to policy. But what I'm going to do, just so that we do keep today on track at this point, is move now into the next session. So thank you, Kirsty, you're joining us anyway. And thank you very much, Joe. So what I would like to do now is to take you into session 2, cultivating advanced advocacy skills. So if I can now invite our speakers for that session to turn their cameras and their microphones on, and then we'll start that panel discussion. Excellent. Fantastic. And I'm hopeful that each of you, Amrit, Philip, you caught the end of the last session, in the sense that there's a couple of outstanding questions. But before we launch into that, perhaps what I can do is ask you both to introduce yourselves. Kirsty's obviously joined us for the first session, so people have heard a little bit about her. Perhaps if I turn to you first, Amrit, and then to you, Phil.
Hello, everybody. I'm Amrit Danoa. It's a pleasure to be here with all of you. I'm a barrister practicing at 45 Gray's Inn Square, and I also chair the Young Barristers Committee within the Bar Council this year. I have a fairly broad practice in that I started out doing a lot of sort of housing, quarter protection work, so dealing with the sorts of individuals and clients that we will come on to talk about in this session. But I also do a little bit of commercial work as well, so fairly broad at the moment. Joe, I don't know if you wanted me to say anything about the session in general, or perhaps we'll wait to get onto that.
Just realised I've turned my audio off. No, not at all. That's really helpful, Amrit. And I should say I've had the great privilege of, again, working with both Amrit and Phil. Amrit in relation to the COVID inquiry, but also in her work as chair of the Young Bar. And Phil, who is my go-to normally when it comes to questions of prison law, will often get a random message from me at different points of the day and evening. So Phil, if you can just introduce yourself as well in a couple of lines.
Thanks, Joe. So I'm Philip Rule. I'm a King's Counsel at number 5 Chambers with offices in London, Bristol and Birmingham. And I'm head of the Public Law Group and a member of the Human Rights Lawyers Association Executive Committee. And I think there was a suggestion when we were discussing how we'd address today that I might say something about my journey to that position that I now am in, and perhaps pose the question, what is a human rights career? So I joined the previous session for long enough to know that we were talking about the higher end of human rights on the international scale, and the kind of changes that people try to make in a more global sense or in a way to large populations. But I think this session is bringing us to advocacy tips for people in a day-to-day practice sense. And so for that, I think it's worth pausing just to contemplate. A lot of people now describe their practice as including human rights practice from a surprising number of areas of law, or for those uninitiated, may be surprising, because your main practice area could be personal injury, it could be crime, it could be civil, healthcare, court of protection, housing. It could be a number of areas, but human rights are pervasive and they can change lives for our clients in the work that we do in the UK. And it includes, of course, human rights include things like access to justice, fair trials, liberty, possession of your property even, and many aspects of people's physical and psychological integrity and autonomy. So it comes up in most areas of law, and that's the whole posit to the Human Rights Act and to the Convention, that it is pervasive in that way. So I kind of wanted to make 3 points for those who are starting out in their careers and are not quite sure how they'll achieve the heights of their human rights practice, that they might want to laudably emulate the things that Kirsty does or that Joe does that you've been hearing about. But in order to get there, many of us start out in a different way, and with those core areas which you build from. So you can avoid despair if you don't get pupillage or a training contract in the human rights, civil liberties set or firm of your dreams. You might still get there, or you may well be using human rights anyway in wherever you do find your feet landing. So firstly, don't consider human rights is limited in that way. There are opportunities in many different ways to use it. Secondly, don't fall into the trap of thinking it's only sexy human rights that matter. There is a lot of human rights to be done at the coalface in the protection and advancement of an individual's human rights, which you'll be able to do in less glamorous or media attention attracting cases. But the whole point of human rights is we hold state to account for individuals. So it's really important for all of us, but also for those who don't have sympathy, who don't have popularity, because that's the basis of human rights. It is things that the state wouldn't otherwise want to do that you're trying to hold them to account for. And the third point, and then I'll stop, is on my rant anyway, I might tell you a bit about me. The third point is that the client is always the focus of your job. So when you are acting as an advocate, that is your responsibility. And there's a lot of sessions today, I think, on client focus and on how you achieve things for clients and deal with them. And that's important, but it's not, you have to sometimes remember when you're dealing with an individual case, part of a campaign or part of your personal convictions, you do have to put the client's best interest first, whether that is settlement when you'd have rather taken the case to court or other things, but that's your role as the advocate. And so just very briefly then, because I've gone on, about me, I did lots of mini pupillages in crime. I thought I wanted to be a criminal barrister. I left university and had a pupillage at a common law set in Southampton. I did a mixed civil criminal pupillage with an emphasis on the first 6 on civil. And then I moved to a small set in Greater London with, again, a mixed practice. And then I became essentially solely focused on criminal and regulatory work for about 8 years, quite a lot of appellate work in that. Then I moved to specialising more in public law, criminal justice related, prison related public law cases. And then I moved to number 5 and expanded my practice, which includes human rights in all these areas, into inquests, civil claims, community care, immigration, extradition, inquiries, and a wide variety. And the most recent string to my bow is animal law. And yes, you can bring a human rights claim in animal law where you challenge the regulation of the government of farming industry, where that has an impact on human health. Even if your real objective might be the animal welfare, it has an impact for us as well. So human rights, pervasive everywhere. You will have chances to develop it, even if you don't find those magic pupillages or training contracts. And do join the Human Rights Lawyers Association as well. We have a juniors committee and we have a senior committee. So you can get involved in that way, no matter what your stage of education or training is. So thanks, Joe. Sorry I went on.
No, not at all. Perfect timing. And I think it's also, obviously from the BHRC perspective, we at BHRC, as I've explained, concentrate almost exclusively on the international side, but it's And that's certainly not the case, as the other Joe explained earlier, when it comes to HRLA. And human rights ultimately are pervasive. They apply in almost every practice area. There's not really a specialism such as human rights anymore. People always say, I want to do human rights work. You need to ask yourself, what does that mean? What type of work do I actually want to do? And we're very fortunate and then great timing. And we've just been joined by Rachel Barnes, who's King's Counsel at Free Raymond Building. She's also an executive committee member at the BHRC. And I'll just ask her to introduce herself very briefly as well, please. Thank you, Rachel.
Joe, thank you for that. Hello, everyone. I'm sorry, firstly, for arriving a little bit late. Somebody has to have technical issues, and it's me. So I think all we've learned is that I can't work Zoom. Anyway, with that, my name is Rachel Barnes. I'm King's Counsel at 3 Raymond Buildings, which started off life as a criminal set, but really does work in crime, regulatory, public law, public international law, extradition as a strong focus. And in my background, I've worked in all those areas. What I really do now is really anything that's got a criminal justice and international law aspect. And as I think Philip said, and Joe, you've said as well, you know, human rights comes up in all those areas, whether it be extradition or whether it be cases such as I acted for Iraqi civilians in the cases against the MOD in relation to abuses by coalition forces in Iraq. I have acted for petitioners who were on the UN Security Council, Al-Qaeda, Taliban sanctions programs, and who were petitioning to be released from those. So I also find myself in the commercial court. Wouldn't have thought that human rights necessarily comes up in the commercial courts, but points of international law and criminal justice and rights attaching to those do. So my background is one which is, I've bounced around a little bit in that I started off my professional life in the States, qualifying and working in New York. I then spent some time in the ICTR in the prosecutor's office, working on a particular project with the prosecutor looking at who financed the genocide and how the genocide in Rwanda was financed. I then went back into academia and took a PhD in public international law, and then I got to the bar eventually, and have been practicing, as I say, in areas really to do with criminal justice and international law ever since.
Thank you, Rachel. And I'm just going to pick up on that one just because we've had some questions already this morning in the opening session that perhaps we'll just deal with a couple of them briefly before moving into the advocacy aspect of this session. And one of them is about the best way to gain practical experience in human rights law as a student or early career lawyer, and what skills or experiences are most important for someone starting out in human rights law. I'm not sure if anybody in particular wants to have a go at answering that one to start with.
Joe, I can certainly say from my perspective, it's pro bono work. You know, a lot of pro bono work gives you the opportunity to access some really, really interesting cases that, quite frankly, when you're starting out as a practitioner, people wouldn't come to you necessarily because you're at the very, very early stages of your career, but they will willingly accept help on pro bono cases from, you know, bright, interested and sparky people who want to make a difference in this area.
It's one of the realities, isn't it, that it's a poorly funded area, and so there is always a need for that type of voluntary work. I mean, equally set against that, the most individuals and organizations working in the sphere also appreciate that to undertake voluntary work, you're often having to come from a position of some level of privilege. And so a lot of it now is fortunately starting to be paid. It may not be paid particularly well, but there are those opportunities there as well. And certainly I would encourage the same. If you're looking in terms of building up your CVs, getting involved. Do get involved with the work of BHRC, the work of HRLA. There are all sorts of different organisations out there covering all sorts of different areas of human rights. Law centres, those types of places as well. Anything that you can do in that regard will always assist you. Effectively, you're building the same skill set. That type of work is what you will use in the future. And part of that is showing a long-term commitment as well. It may all look very attractive to have a 1 week placement in America on death row, or 3 weeks here and 3 weeks there. But actually, what's far more impressive is, you know, the 9 months that you've committed to down in, I don't know, an hour away from your home or wherever it may be, in a law centre or something like that. It's far less glamorous, but actually you will see a lot more, and those types of things. Phil, I don't know if you want to add anything on that one.
I unmute. I usually forget to do that. I've managed it this time. I mean, I agree. And part of obviously the benefit of doing the pro bono is also you're gaining experience, you're gaining practice. I also think going into court and seeing others and how they are dealing with cases can help to build the sort of skills that you're trying to build to try and help your clients and get the work come towards you. One of the things that I think can be difficult for someone starting out when you're given something which can be difficult to present is nerves and dealing with the pace of things and being able to put forward your case effectively whilst you're dealing with those issues. And if you've practiced and you've seen others and you've thought about it in advance, then you're going to be that much more effective at overcoming that.
Thank you. What I'm going to do now is move on to the real substance of our session, which is really talking more about advocacy skills in your courtroom practice. It may be outside of court, it may be negotiation, it may be those diplomacy aspects. And I suppose that one of the hardest things is when you're at the beginning of your career, ultimately. You may not have significant experience yet. All of these places can frankly be intimidating, and they're still intimidating even when you're at our level. So Amrit, I don't know if you've got any thoughts that you would like to add from the sort of the junior lawyer perspective in terms of techniques for developing skills that you can refine, and the preparation that you can do.
Yes, I think just touching on what Philip said, I mean, there are opportunities before you start out in practice and you're doing those less glamorous cases, which may be very short hearings or applications before you go on to more substantive trials. But learning about what those techniques are and what's most effective in a courtroom setting and what's most persuasive is sometimes gained through actually seeing it done. And of course, in this profession, you know, you have to be practicing those skills and your advocacy skills continuously. And as you say, as you go through, you know, being a barrister and the career, you're constantly refining those skills and making it better. I mean, as a junior lawyer and a young practitioner at the bar, I think even if you're dealing with a very, very small hearing, which you may be given only a few papers on, or you're dealing with a much more substantive trial where you've got a lot more time to prep rather than just being told the night before you have to be going to court the next day, which happens far more often than people think before they come into the profession. I think there's no substitute for sort of making sure that you're fully prepared and that you know your case inside out. And a lot of people will say that and you'll hear it very often. But I think if you're able as an advocate to appreciate what your case is and what you're seeking as a remedy, but also understanding the weaknesses of your case, whether or not it proceeds to a sort of final substantive trial, or you find that you're advising your client about potential settlement. I think that in terms of familiarity with your case and making sure you know each and every aspect really like the back of your hand and understanding it so that you can then deliver that persuasively when you're talking to judges in a courtroom will develop and build that confidence for you. And I don't think there's any substitute for that. So preparation is key, making sure you understand what it is your case is about, understanding what your instructions are, whether or not you believe in what your client is saying is secondary. But it's about acting in the best interests of your client, assisting the court, understanding, of course, what the judge is asking you, and sometimes that will give an indication as to potential weaknesses in your case, which hopefully you would have thought about beforehand and you should be doing. But I mean, just to close on that, it's, as I said, it's case preparation. But when you're sort of in court and you're making submissions, whether or not you've done so previously by way of a skeleton argument, which is of course written advocacy, and then you appear in court and you're using that, it's of course an aid to your oral submissions, and it's not a script as such. But you will be able to make, I would say, clear and concise submissions, and that's what really makes advocacy effective orally when you're in court, and that's what judges want. They have limited time. We all think that they may have as much time as we do as advocates to read into cases and understand them, but they're obviously juggling a caseload as well, and so you have to be flexible in that sense to be prepared for judges to even having overlooked some of the sort of simple parts of the case that you think you take for granted that they know about. And if you are well prepared and you understand your case properly, you'll be prepared at at any moment when the judge is asking you a question, simple or more complicated, to be able to put your case to them. So yeah.
No, that's incredibly helpful and completely right. I mean, for what it's worth, I find one of the most helpful things to do is to put yourself in the shoes of your opponent, because that way you do identify where the grenades are effectively in your case, where the weak points are in your case, and you need to be able to answer those points. There's no point pretending or ignoring them, or worse of all, not actually appreciating them before you actually begin your advocacy, because then you really are dealing with what Philip was talking about earlier, which is responding to things while you're on your feet, while you're trying to think it through. Preparation is sadly key, and we have it drilled into us, don't we, right from the very beginning. I wish it weren't so, because it'd make our lives a lot easier, but it sadly is. So turning now, if I can, to the refining of cross-examination skills. So obviously, a frequent aspect of an advocate's practice is witness handling and dealing with witnesses in cross-examination. And some cases can be very difficult. They can be emotionally charged. People often have a lot at stake within legal proceedings. And one of the aspects that I wanted to talk just a little bit about today was, how do advocates really deal with that? How do you refine your own cross-examination skills so that you can anticipate and respond to the types of challenges that arise in those sorts of cases? The evidence that you receive back, how do you adapt? How do you deal with that when it comes to moving forwards? Kirsty, I'm going to turn to you, just because I know you've had quite a lot of experience in this sort of witness handling.
Yeah, a few points. First of all, I'll come on to this. Firstly, with some of the questions, access to courts. How do you get in observing a court in London? Just go. The courts are open, so you can go and sit in there. But also you can contact chambers to see, and you can contact the Bar Council to see if you can do a mini pupillage with somebody. And it doesn't have to be a week long. It can be a couple of days here and there, where you can actually shadow the barrister at court. But you can pop into any court and observe. And in fact, I remember doing this as a student, popping into a magistrate's court, popping into a Crown Court, a county court, and also the High Court actually at one point, to see what was going on. Do you choose international or European human rights? Both. If you're working in international law, if you're working in human rights law, you are applying both. Even if it's in a domestic situation, you still will be looking at the European Convention of Human Rights, which obviously is directly applicable through the Human Rights Act here. And also you probably would be looking at some of the international treaties as well, where although not directly binding, they are law that the state should not be acting against. So you'll be referring to those as well. In terms of cross-examination, often people, when they're being cross-examined, have a range of emotions. And so first of all, you need to consider, who is your witness? Is this a witness actually you kind of want to get on your side? Or is this a witness who, in fact, you need to go in on the attack? They are somebody who's attacking your client, and you've got a case where you're saying this person is lying. There might be a reason for it. There might be some bad blood between them. So you always need to work out what's your aim? What's your objective? And I remember somebody once said that cross-examination does not have to be cross. And that's so true, that you can be very effective cross-examining, and in fact more effective cross-examining, whilst not acting in that blustery way that we often see, particularly in US dramas. So practically, what I do cross-examining, it's preparation, which has already been referred to. There's no shortcut to preparation, and whatever you do, it's always the key. Whatever you do, if you're going for a meeting as an intern, if you're going for any application, if you're going to court, preparation. So I will write down my questions, and I will know where I'm going to finish. But also, when I'm writing down my questions, I will cross-reference them to where I know I'm probably going to be, frankly, tripping up the witness, that they're going to be saying one thing, and I know that they've said something different, say a couple of years previously, and so I'll be putting that to them. The key is to listen to the answers of your witness. And so I can't go down the route of my questions that have been written. I'll need to go off and follow the witness and then bring them back. But often you do see in cross-examination that the person is not being listened to. And in fact, there's lots of real kind of gold nuggets that are coming out of your witness's mouth that the advocate is ignoring because they are too conscious on just going on to their next question. So you really need to listen to what's being said. And that way you actually you're different between being somebody who's really slightly going through the motions and doing a perfectly okay job, and somebody who's doing a really brilliant job. Always treat the person with dignity. Don't match their loss of temper. Sometimes they do lose temper, shout at you. Don't match it, because they will be undoing themselves in front of the tribunal by becoming aggressive. Sometimes witnesses are very emotional, and sometimes they are in the wrong place at the wrong time, having to recall something which is horrific. And so flag up in advance if you're going to come onto that topic. And this is what we're trained on all the time with vulnerable witnesses. You flag up. I'm now going to ask you about that time, that place, that day. The witness knows this is the horrific thing I saw. And so therefore, you can also caveat it with, I'm asking these questions not to upset you. However, Mr. Bloggins, who I'm representing, considers you might have got some bits of what you remember wrong. So I have to explore these with you. Is that, if it's a child, is that all right? And you can have breaks and so on. So it depends on the witness. Always finish on a high. So you might have had an absolute disaster. Never, of course, none of us here would ever have had an absolute disaster of cross-examination, but always finish on a high. This is my case. This is what I'm putting. And so you've got the account that you're putting forward, which is the correct account, ringing in the ears of your court as the last thing you do before you sit down. So it's important to sit down on a high point so everybody's still got faith in you.
Well, thank you, Kirsty. I'm now going to move to another aspect of advocacy. Obviously, witness handling is one aspect, seen in certain areas of practice more than others, ultimately. But what is key across the piece is that there is a lot of submission-based advocacy. And in relation to that, Rachel, I'm going to turn to you. You obviously do an awful lot of submissions-based advocacy, so I'm hoping you can assist us here. And what sorts of strategies can new advocates employ to structure and present complex legal arguments so they're clear, so that they are concise, so they capture the court and everybody can understand the line of the argument?
Joe, thanks for that. So I think the first thing I would say, and I was thinking about the title of this session, of cultivating advanced advocacy skills. I think the first thing I say is we all are doing it all the time, and I don't think we ever get to a point where we say, right, we've nailed that. But it is a constant work in progress. So just as young advocates are doing it, trying to get better at what you're doing, so are we, so am I. I always come out of court going, oh, could I have done that better? How did that go? But with that, I think the starting point is, as everyone said, it's preparation. But when I'm thinking about submissions, particularly after I've done my written argument, and I then think about making the submission to the judge. I think, well, what does the judge need in oral argument? They need the summary of your points. They need you to identify concisely the issue that they have to make a decision on. And you need to identify what it is you are asking them to do. So what, and no, that all sounds very simple, doesn't it? But it is difficult, and it requires a lot of thought ahead of time in how you present those arguments. I try to think of it as a triangle, and at the bottom of that triangle, you've got to make the basic points. You've got to put in the building blocks, and then you go up and you to the most complex aspect when you're actually in the meat of it. I know certainly I have something I'm very aware of myself, is that I often just go straight to the top of the triangle without necessarily having made sure I've ticked off the building blocks first. And sometimes if a judge has got the building blocks, they will tell you they have, and they will say, no, I understand this is the position. Is that right? Now, can you help me with this? And if that's the case, well, you adapt, you're flexible, and you pivot to that point. I think I also, increasingly at an appellate level, there are two things which I need to bear in mind when making submissions. Is firstly, particularly if I'm at first instance, but thinking this is a complex point which might go on appeal, is to say to the first instance judge, part of my argument is point X. I recognise there's binding authority against you on that, so I'm not going to take much time and trouble with the court, but this is our point, and my lord will appreciate that I need to preserve that point potentially for another place. Or, you're signalling that there may be an appeal on that point. The other point, particularly when it's a complex legal point, is judges, when they're really engaged in it, will be thinking about, well, what are the ramifications? If I decide it this way in this case, what's that going to mean in another case with a slightly different fact pattern? And increasingly, or in appellate argument, you find that very often a judge will say, okay, well, look, if you're right on this, let's change the facts slightly. What does it mean for this point? And so I think you need to be thinking in those terms as well. You can't anticipate everything a judge is going to say, but you can, if you've thought about those points, you can argue them and have the confidence to make your submission. You've got an answer already in respect of those. And the other point that is related to this is the counterfactual. Well, if I'm not right on this point of law, this is the ramification of it. So all those are, I think, so they're at the top of the triangle. They're the points that that when a judge is engaged in the legal argument, and you have those wonderful moments where actually you have a discussion on a point of law with the judge, which is, I find, a really fulfilling thing in court. Those are the types of questions and the way in which they may be framing their questions, because they're thinking not simply about this case, but what are the ramifications for other cases if they decide a point of law in a particular way.
Thanks, Rachel. I think you've hit the nail on the head. It's the foundations. It's taking the judge from the start to the end, in short. And I think certainly from my experience of sitting, that's incredibly helpful, because ultimately you're looking at how you're going to write your judgment. And if you can effectively almost write their judgment for them, then you're going to go a long way in terms of that argument, in terms of people being able to pick it up and follow it through.
And actually, Joe, if I can just give you one example on that, fairly recently I was in front of a judge, and I had read her previous judgments in the same area of law, and I knew, and I'd seen there that she'd done something really interesting as an appendix to her judgment. But it was all about statutory construction and the impact, and part of it was tracing the history of this legislation from the EU legislation now to post-Brexit to autonomous UK legislation. And she had done a table in a judgment in another case that had the provisions of the EU law and then the provisions of the sort of old UK law and then the new provisions. And I did exactly the same because I knew that she liked that. And actually it was a really effective way of very quickly tracing the history of these statutory provisions. So it's a really interesting point that you make of, can you write the judge's judgment for them? Can you do something that, not cut and paste, but that they can see as part of their judgment?
And also, I think it's worth pointing out that, albeit sometimes, you know, judges do have time, and because X amount of time has been allocated to an argument, often judges are also ruling on legal arguments in the middle of court days, in the middle of busy lists, in the middle of trials. There are all sorts of extraneous pressures upon them too. And so you really do want to make it as straightforward as possible for them and get to that point, get to the heart of it. I can see, Phil, you're just leaping to get into this conversation, aren't you? Go for it.
I just want to share some advice that I received when I was a student from a silk who came to our university and spoke, actually, which is a lot of what Rachel has just been explaining, which is you're trying to tell the judge why you win, not just because you're right, but why you're right and why it should be that way. And that is a lot of the things that Rachel was saying about empathizing with the judge's position. What do they need to know? What are the effects of them agreeing with you or not agreeing with you? How does it have ramifications? How does it play on to other things? So when you get floodgates arguments or other situations being posited. But so if you think when you're analysing the cases, when you're reading the judgments, and as Rachel said, no substitute for reading judgments. It might not always be the same judge, but you just get an idea for how judges are deciding cases and on what things you can turn a case one way or the other, on what factors. And so using that with just the why question. Okay, that's what it says there, but why? Or that's what happened there. Why did that happen there? And using that to your advantage.
Yeah, can I just add, just practically as well, one thing at this start, so we're probably talking about two sort of separate areas here. In a way, you've got the complex argument where your judge has probably got a reading day, and then you're in court, and there's lots and lots of authorities, and then you've also got where there's a legal point, and you're in a trial, but you put some written submissions in as well. Make sure the judge has got everything, first of all, that you submit to the court right at the beginning. And also, again, just flag up where you're going. So flag up that what it is, what they're going to hear. And people just relax with that communication. Okay, the argument's going to be in three parts. The first part that I'm going to address is X, and the authorities that I'm going to refer to for that argument, the first part, are found within bundles 1 and 5. So the judges have then got bundles 1 and 5 and found them, and because there's nothing worse than somebody scrabbling around and you yourself inadvertently putting your judge who you want on your side under any kind of pressure. And then they might get irritated if they've picked up the wrong bundle and so on. So if it's nice, if you set it out, I think how things start really can set the tone. I mean, you can recover from a bad start, but if you set the tone really well at the beginning, it makes your life a lot easier. And that also goes to being at court early. Your presentation, don't go with stuff, dropping your iPad and things flying around. If your presentation looks organized, then you're starting off, and your tribunal's going to have some confidence in what you say. So that's just a little bit around perhaps the psychology of it. And there's lots of guidance on, we've got people different levels on this call. I know there's lots of guidance now on not to overwhelm the court. Don't show off that you're so clever that you've added another 30 authorities, because you can just irritate. That's not what they want. They want the leading cases and also those that you're going to rely on. So you shouldn't be in a situation where you've got about 3 authorities or whatever that you've not even referred to. So, which comes back to the preparations. Those are my only little bits that I would add, but really I agree with everything everyone else has said as well.
Thank you. And I'm just going to ask one final question now of our panelists, and it really deals with the situation where you're getting those objections from judges, you're getting the unexpected effectively coming back to you, you're being made to think on your feet. It might be evidence from a witness, it might be questions from the bench, it might be that your opposing counsel has come up with something that you've not thought about, or indeed, as it happened to a colleague of mine in the Supreme Court very recently, albeit one question was certified, when they got there, the court was interested in an entirely different point that nobody had considered. So not least are they having to go back, but they were also trying to deal with that on their feet. So I don't know if there's any sort of top tips in that regard, and I'll come to each of you in turn briefly in the few remaining minutes that we've got left. So quick fire thinking, quick fire questions and answers. Rachel, can I come to you first?
Joe, yeah, of course. Preparation, again, if you've done your preparation, you'll be more confident in the flexibility and the pivoting to points being raised, and you want to be able to answer them rather than skirt around them. One thing I would say, actually, Joe, this follows from what you've just said about the Supreme Court, because a colleague of mine had a very, very similar situation fairly recently. They got
it might be the same colleague, ironically, Rachel, because she's in your chambers, so
it may well be. It may well be. But one thing that was really impressive is that if it's the same person, they had the confidence to say, I can't deal with this on my feet. And they said that to the Supreme Court, and the Supreme Court said, yes, okay, we'll list it for another day. And that, I think, takes real confidence to and it's easier to do in submissions as opposed to witness handling. But if it is that important, and if it is something that about which there's been no warning, sometimes the proper thing is to say, I will come back on this, but I can't deal with it right now.
It's quite a brave thing to do, frankly, isn't it? In a Supreme Court hearing, X amount of time has been allocated to deal with this issue. You've been waiting however long to get to it, years of litigation typically, and then obviously you're thrown a curveball.
Yeah.
But the ramifications are hugely significant, and you don't want to do that sort of thing on the hoof. You don't know what the impact will be across the piece or across the board. Amrit, can I ask you for your thoughts?
Yes, absolutely. Thanks, Rachel, for what you said. I think it's just quickly picking up on that. I think it's hugely important that, of course, with preparation, you will have taken the time not only to understand your own case, but to appreciate what the weaknesses are, what the counter arguments are. And in that way, you will be hopefully better prepared to be able to deal with those questions, either from opposing counsel, but also from the bench. But of course, there will be moments where there'll be questions put to you that you may not have thought about, or the extent of what's being asked and what the impact is for your client's case. And in those situations, I think it is important to just take that moment to stay composed and try and be calm under pressure, and say to a judge, I need to take instructions on that, because that's not something I've even considered with my client or my instructing solicitor. And it's important that you don't say something which hasn't been discussed with either of those two. And more often than not, judges will be happy with that, and they'll say, I can give you a short adjournment if it's a fairly sort of narrow issue. Or, for example, as Rachel said, it may be that it will be relisted at some point for you to be able to go away and do that. But I think on occasions where you are being asked questions by judges that are really trying to test sort of your own case, sometimes advocates will say statements to the effect of, well, they get a sense that the judge is not with them, and they'll concede quite quickly and say, well, I'm in your hands, and if that's how you see it. But I think judges appreciate as well that they're sort of pushing you on something, because they really want to be able to understand both sides of the case, so that they're able to then go away and make the decision that they need to, and they properly understand what the competing arguments are. And I think there is a skill in that, where you're responding to a judge and you disagree, that you can do so robustly, but you are able to do so politely as well, and still advance the contrary view, and you shouldn't be afraid to be able to do that. So I think those would be my tips. But overall, I think, as everybody has said, and we started with, was more often than not, if you thoroughly prepared your case, you'll be in a better position to be able to deal with those sort of tricky issues.
Thanks, Amrit. I was going to come back to you, Phil, and back to you, Kirsty, but I'm aware there are a couple of questions that have popped up very briefly. One is about, from the solicitor side, is there anything we could recommend for solicitors to bear in mind when handling these files, cases, or when instructing us? From my perspective, it's really having a solicitor who's fully engaged across the material, has their own views, has considered the issues that you're considering. You're working as a team. You may be the front-facing person in court, but ultimately you're only as good as the team that you've got behind you. And on a practical level, it's much more mundane than this. Bundles, freaking bundles at any level of appellate advocacy, they always go wrong. Everything always goes awry in some way, shape, or form. Tune into the Supreme Court, and they will always be struggling with pages in bundles. And that can detract massively when you're in the middle of a hearing and you cannot find the right document, and everyone gets a bit hacked off. So I just wanted to just add that. I don't know, Philip, if you wanted to say anything about that.
On that, can I say timing as well? It's much more helpful to get involved with the advocate earlier than later. Quite often, some of the problems that you face are that you get very late instructions, by which time it's almost too late, or is too late, to do something which might well have been useful. So if you're going to have a team, set them up as early as possible and then benefit from that teamwork. And can I just go back quickly on the point about adaptability? Just the preparation that's been talked about and the thinking that goes into it is absolutely vital. Then the next stage is the more basic. How do you prepare yourself to use that? And I think the way you prepare your notes to speak from for adaptation, you need to be able to say, okay, I might be under time pressure. What's essential, what's not? I might be under a judge who's got no interest in one area, but wants to have a much more detailed discussion of the other area. So the way you arrange your preparation to be able to respond to those indications you're getting, or just a lack of time to be able to deal with everything that you'd wanted, but knowing what's essential not to miss, what are the most important points, what's really going to matter. That flexibility comes from how you put that preparation down on paper, I find, and then, or electronically if that's how you work, and able to navigate through.
Thanks, Phil. I think we've reached the end of our session now. So thank you to each of the speakers. I hope that that's been helpful to all of you that are following it along remotely. Hopefully you've got some top tips. Hopefully I think the one message that you'll probably come away with is preparation when it comes to advocacy. Not the sort of end point, but the start point really is really what determines how it goes. I'm going to wrap this up now, please, and I'm going to hand over now to Heidi Dykstra. She's going to chair the third session, Trauma-Informed Approaches to Human Rights Advocacy. Heidi is a colleague and barrister at 33 Bedford Row. She's a member of the Executive Committee of the Bar Human Rights Committee. So Heidi, over to you and our speakers, please. We'll ask all of the speakers to turn off, our speakers to turn off our cameras and your speakers to turn on theirs. Thank you.
Thanks very much, Jo. Just wait for everyone to get online. I think we're okay. Great, we're all here. Well, again, my name is Heidi Dykstra, and thank you so much for being here for this important discussion about human rights, about trauma-informed approaches to human rights advocacy. Before we start off, we have an excellent panel here today. I'm going to do a bit of housekeeping. So as with the other sessions today, we have about 30 minutes for our discussion, and then we're going to aim to move to about 15 minutes of questions and answers. So if anyone has questions, please do put it in the question and answer chat box, and then we'll move to those as soon as we get to the question and answer portion of this discussion. So let's kick it off right away because there's a lot to discuss in a short amount of time. And what I'm going to ask first is that each of our panelists share your own experience and interaction with the issue of trauma-informed approaches to human rights advocacy and an initial brief insight into the issue. So let me start first with Zoe Harper, who's a barrister at Doughty Street Chambers. If you could just introduce yourself a little bit more, tell us a bit about your experience and some initial insights. Maybe keep it to about 2 minutes, if that's all right.
That's great. I'm Zoe Harper, and as you said, a barrister at Doughty Street Chambers. I practice predominantly in refugee, immigration and human rights law, and that means my clients are predominantly refugees, torture survivors, victims of trafficking, and people with serious mental health and other health difficulties. And so I represent those client groups in accessing protection in the UK. And so working with trauma is fundamental to my practice. I would say most of my clients have experienced trauma in one form or another. I came to the bar later in life. I have a kind of 20-year career history in refugee protection across a range of domains through direct casework with refugees and asylum seekers and other migrants, in academic work and policy advocacy, as well as work in therapeutic organisations such as Freedom from Torture and Rape Crisis. And I would say that my practice is very much informed by that background and those therapeutic approaches, and in fact the much wider experience of those organisations in working with trauma. And I see it as one of the strengths of a diversified bar that we bring experience from practice in other areas, and so really encourage everyone to draw on their experiences in other practice areas. I would say a trauma-informed approach to human rights advocacy is integral to three things: to achieving the best evidence from our clients, secondly, for supporting our clients through what is likely to be a very difficult process and avoiding their re-traumatization, so working holistically to support them through difficult court processes. And thirdly, it's integral ultimately to outcomes, to securing justice and protection for our clients who are most likely to fall through the gaps otherwise. It's why I welcome the organisers championing of trauma-informed approaches as part of human rights education. And I think it's something that's as important as our knowledge of the law. And so focusing on training and skills in this area is integral to our practice. It's fundamental to mine, and it's likely to be integral to other human rights practices too. So it's really important to maintain a focus on this type of training and skills as a core part of practice and continuing professional development, even though it traditionally hasn't formed part of modules on bar courses and previous training. We might not be able to cover the full terrain in this session, but at least for my part, hope to provide some resources and indicators of where to look to for further support and training in this area. I think that's me to start with.
Thanks very much. Well, let me now move to Professor Martin Jones, who's a professor of international human rights law at York Law School, University of York. If you could also introduce yourself a bit more and some initial brief insights.
Yes. I mean, I suppose I began my career in the legal profession as a refugee lawyer. So kind of like Zoe, kind of share some of the need to kind of embed trauma-informed approaches, although they weren't called that back then, within practice. Since moving into academia, I've been continued to engage with practice communities, particularly around asylum, but often in places further afield that seem initially quite dissimilar to the UK. So places in the Middle East and Southeast Asia, where legal frameworks of the legal profession have been less engaged. And that's necessitated an engagement with issues around well-being and for that matter, safety. And so a lot of my research now focuses on issues of risk and well-being. And I think one of the conclusions I've reached is, although the particular contexts obviously can differ quite a bit, that there is really a universal need for us as members of the legal profession to really deal much more directly with issues of trauma and well-being. I think we have perhaps as a profession avoided it, like many other professions, for a long time. But I've come to the conclusion that kind of trauma-informed practice is not an option. It's necessary, and it's good practice. I mean, it is good advocacy. Beyond that, I would, I guess, agree with also something else Zoe said, which is that I think for me in recent years, as part of my research, I've developed psychological training programs, applied them to a range of activists and lawyer communities. And it's been one of the most breathtaking examples of how, as a somewhat older practitioner and academic, how I can very immediately reap dividends. The psychological training and psychological first aid training, the trauma-informed approaches training that I've received has paid huge dividends in not just my kind of research and advice to practitioners, but in my relationships. And so I would second Zoe's point about the need to embed this kind of training in our professional education, because it will, as much as anything else, improve your relationships and your advocacy.
Thanks very much. Okay, can I move now to Oliver Jackson, who's a barrister at 11 KBW and a member of the Human Rights Lawyers Association and the Executive Committee.
Thanks very much.
To you.
As Hayley says, I'm a barrister at 11 KBW. I act for claimants and defendants in judicial review. So that means cases for and against central government departments, local authorities, and regulators generally. So that's generally my practice, although I also practice in employment law and competition law as well. I'm going to talk about my experience concerning trauma in courts later, but in terms of my journey to the bar, like Zoe, I also moved slightly later than normal, but not after a 20-year career by any means. I was a civil servant for a while and then worked for various NGOs. I worked for Liberty and Reprieve and the Bar Pro Bono unit. I was also a judicial assistant at the Supreme Court for a year. And like Zoe, I agree that bringing a range of previous experiences can be particularly important in this area of practice, especially.
Great, thank you. And finally, Jack Dingley is a pupil at Kenworthy's Chambers and former head of casework at Manuel Bravo Project. So over to you.
Thank you, Hayley. So yeah, my name is Jack, and like me, I'm transferring to the bar. I'm only just starting at the bar now, but I've previously worked in the third sector and for a solicitor's firm doing legal aid work. My practice is entirely in asylum and immigration work, so very heavily involved in corporate trauma-informed approach. Particularly at the charity, our work was for asylum seekers who do not get legal aid. And you all know you don't get legal aid if a solicitor deems that your case has a less than 50% chance of success. But anecdotally, what we see is that cases that are deemed to have low merit are actually cases that involve very vulnerable people who have a great deal of difficulty engaging with the legal process. And so through that, we've learned that actually by implementing trauma-informed practice, we reduce the outcomes. That's my initial thought on trauma-informed practice.
Okay, thank you. Well, let's move into the discussion portion of this session. And let me just start with posing a question. How can human rights advocates recognize and address signs of trauma in clients? And what practical techniques can they use to create a supportive and safe environment for those they represent? And let me direct this question first to Zoe, and then Martin, if I could come to you afterwards.
Thanks. I identified three things that I'd like to speak to. First of all, I think it's useful to remember that a trauma-informed approach affects all aspects of a case. Certainly as barristers, we're often called on to support junior colleagues in their more direct work with clients, and also to review written materials, as well as do direct work with clients. And one of the things that we often do when we're reviewing materials is looking for gaps, what is not said and what is missing. So that brings me to my second point, which is around the importance of preparation. In order to be able to identify those gaps or look for what's missing, it's really important to know a country context or the context within which you're working. For example, what typically happens to women in that context? What happens to activists, to detainees? So that you can identify from the narrative that you have in front of you, or the one that you're taking, what are the gaps in that narrative in relation to what you would, normally expect or anticipate in the human rights context. It's important to know indicators of trafficking so that you can identify any concerns around trafficking. And it's also important to understand the signs and symptoms of trauma, of post-traumatic stress disorder, and how those impact on our clients. Some useful materials that can expand on those topics around symptoms of trauma are materials in the Advocates Gateway, but also the Centre for the Study of Emotion and Law has done some really phenomenal work around the impact of trauma symptoms on memory, on providing evidence in interview, providing evidence to court processes, and it's a really fantastic starting point. And then thirdly, in terms of practical techniques to create supportive and safe environments to support disclosure and evidence, I would really recommend the Helen Bamber Foundation Trauma Informed Code of Conduct, which you can Google for and access very easily on the internet. And it is best practice developed to work with, for all professionals to work with trafficking survivors. But the advice it provides is really useful as a touchstone in all aspects of human rights practice. And certainly, even as an experienced practitioner, I go back to it again and again, because as it says, it's helpful to go back to, so that you're not always drawing on your own emotional intelligence and intuition, but you can access this kind of touchstone every now and then. And it covers a range of topics, all of which are really important in considering how to create that sense of safety, such as understanding presentation, communicating a sense of safety to clients, and being awareness of communication, that you're that's not just your verbal communication, working with interpreters, how to provide a calm and consistent environment. And one key thing, particularly for barristers, is around creating the illusion of time, how you create in your session with a client the illusion that you have all the time in the world for your client, even when you know that your schedule is busy and your diary is crazy. It also covers topics such as managing asking for sensitive information, managing remote working, aftercare, and, as we'll come on to later, the critical importance of self-care as an element in the mix. It goes into a lot of detail with sort of tips around that, far more than we may be able to get into today. So I'd really recommend that resource as a really useful resource for practitioners or those thinking about practice as a way of developing those skills.
Great. And Martin, did you have any additional thoughts on identifying signs of trauma, and then also any tips or techniques on how to address it sensitively?
Yeah, I think the first thing to comment is that I think trauma plays out differently for different people. I mean, it plays out differently for the same person often over time. And so really this is a practice or an approach that needs to be embedded within your practice more generally, as opposed to something that's kind of triggered by a particular sign that you recognize. Because the point here is that there's a multitude of signs and you may not initially recognize them. I think that at this point, there's a huge array of resources, and I second Zoe's references to range of supportive materials that give you very concrete, specific practices that you can adopt. I've also found the European Human Rights Advocacy Center's guidelines useful, that similarly talk about kind of the very concrete ways that you can create a sense of safety, comfort, and accessibility for clients, and how you can communicate in a trauma-informed way. When it comes to the specific interviews, I guess I would add that there's although I don't love where it began, I find the forensic experiential trauma interview guide, which kind of came out of policing in the trafficking context. So I'm slightly skeptical about kind of, in a sense, its origins, but it's still useful in the sense that it flags kind of ways and approaches to sensitively solicit often quite difficult information. And going back to kind of my original overarching point that I think trauma-informed advocacy is good advocacy, I think one of the things that trauma-informed advocacy does, and that these guides to how it's best to interact with clients can provide, is the kind of evidence that you need to win cases. And so, you know, one of my memories is the observation from a lot of the guidelines around how memory works. And so he's right, there's been a lot of research around this too, and how, for example, sensory memory works for individuals who suffer trauma. And realizing that and being able to use that knowledge of how trauma operates and talking about traumatic memories through sensory prisms, through ideas of smell or taste or sound, can often give you the kinds of accounts that you need, you know, with the kind of color of truth that's needed to have a decision maker to believe it. So, you know, it shows you that kind of the empathetic trauma-informed approach will also be a way of winning the case in the end.
Well, I want to move over to Jack and Oliver for a bit of an extension to this. You know, once an advocate recognizes signs of trauma, what are those ethical considerations that then come into play, you know, involving balancing the trauma-informed approach with the need to gather essential evidence, you know, especially when a client's testimony is involving reliving traumatic experiences. So do you have any tips or insights into how to balance those ethical considerations? Jack, can we start with you?
That's with everything. There's it's running everywhere. I think the primary one that might influence here is what is your statement of your client. You've got balancing act there of, so you're making a statement from victim trusting. You need to establish the legal components required to meet the test. One of those requirements is the exploitation. And by taking a statement on that, you run the risk of both re-traumatizing your client, but also damaging their ability to engage with the legal process. A witness statement is early on, if immediately someone is speaking about talking about their experiences, that's going to trickle through for a Home Office interview, is going to trickle through for their bill hearing, and it has an effect as well. And the first like still answering how to do it really. And what Zimi said is really good. I'm sorry for my connection. I'm sat in the corridor of the RCJ. So if you can't hear me, please let me know. Just in terms of what you can do to balance that, it's all about preparation. So plan for your meetings, make sure that you read your medical document beforehand, make sure that you know what the issues are. If you can get a lot of information from the documents and you know what's in dispute, then you don't necessarily have to go over it with you. You want to, sorry, can you not hear me at all, Heidi?
Yes, I think it might be a bit patchy. I think others might be experiencing the same thing. I can hear bits of it, but some, you know, not all of it's coming through.
Let me know if you want to pass over to Oliver. But the other things in terms of preparation are just about setting ground rules and managing client expectations. So if you could make sure that, 2 seconds. Perhaps that's better for us.
Much better, it seems.
Okay, so apologies. So on the balancing act, most of what I was saying was just about preparing. So narrow down what it is that you need to engage the client. What can you ascertain from medical information? What can you ascertain from the issues? Is this issue in dispute? Does the client have to engage with it? Ground rules meetings for clients before engaging in the case in any way, shape or form are always very helpful because you set expectations. So if the client knows what it is you're going to be discussing, it prevents them from having to worry about what they might have to discuss. If you signpost as you move towards traumatic events, then clients can prepare themselves for that. And then, of course, you want to signpost away from it and you want to de-escalate afterwards. And it's all about creating these safe environments. You have to engage with the issue in order for the case to be done, but make sure you do so in a safe way. I'd echo the resources that Zoe's mentioned. The other one I would add is the Equal Treatment Bench Book, particularly if you're working with appeals, because it's the resource that the judges use. And if you start citing a resource that the judge has to use, then they're probably going to start putting their head up and listening to what you have to say. I'd also add, when doing the balancing act, the trauma-informed approach doesn't mean not engaging with your client. It doesn't mean treating them like a fragile piece of glass. Asylum seekers, people who've been through trauma, they are very resilient. They're more resilient than you might often think, and it's their case. Your job is to create the environment for them to engage in the process. You give them the tools to allow them to present their case. It's not about removing the autonomy away from them and preventing them from being able to engage. So that's where your balance is. Finally, just one ethical consideration is late disclosure. Late disclosure may also mean that you've inadvertently misled the court or the body that you're operating with. You are, of course, obliged to correct that if you've done so in order to continue preparing, but often this won't be held against the client. Late disclosure in things like accounting experience of trauma, it's well known that this is commonplace. So make sure that you get ahead of it. Just make sure you're correcting it as soon as possible.
Thank you. And Oliver, did you want to weigh in on this?
Thanks, Hayley. So my first point is essentially to reiterate the crucial point that Jack made there, which is that as the advocate, you have to get instructions. You have to get proper instructions from the client, both on what is helpful to their case and also what could be unhelpful to their case that you will have to address in court. And that's where the balancing act that Jack mentions comes in. And that can lead and does lead to some difficult conversations. I noticed there's a question just there from Mariam asking, how do you, any suggestions on how to de-escalate? Sometimes these conversations do escalate. These conversations do lead to raised emotions and distress. I personally find that the best way, having set the ground rules that Jack mentions, the best way to deal with that is to take some time, pause, give them a break. I'm sure the others will have suggestions too, but personally for me, that is what I find is the best way to deal with that. Just two other points, practical points on how to gather essential information without re-traumatizing an individual. Something that I've seen done a few times, which I personally think is quite effective, is in court for the advocate to explain to the judge, I have a vulnerable client, I've taken instructions as best I can. These are the factual matters that we rely on as set out in the witness statement, but there may be some points which did not come across because of the situation, because of the client's vulnerabilities. If these emerge during cross-examination, then I would like a chance to address them in re-examination in front of you. And that serves two purposes. Firstly, it flags, well, three purposes. It flags to the judge that if there are any factual matters that come out that weren't previously set out in your evidence, there's an explanation for that. Secondly, it flags for the judge really loudly and clearly that this is a vulnerable individual, that they have to, and they should bear that in mind. And thirdly, it means that you have a chance. There's nothing surprising, as can sometimes be the case, if you have to go into some depth in re-examination to address any new matters that you didn't previously get beforehand. And it is, as all advocates can tell you, it is simply a reality of the job that you think you have got all of the instructions from your client, and then something turns up in cross-examination that just previously hadn't arisen before. And that can be especially important. It can be especially important to realize that in this context.
Great. I think so far we've addressed how to approach signs of trauma within our own clients and how to look out for this, but it's also very important to look out for ourselves as well when we're working with clients who've gone through traumatic experiences. So let me just move to a question that focuses on this. How can advocates manage their own emotional resilience and prevent secondary trauma or burnout when working on cases that involved intense human suffering? And so maybe let me start with Martin. Would you like to speak to this.
Sure. No, I think this is a really crucial issue in terms of the sustainability of legal practice, particularly in fields like asylum. I guess the first thing to observe is that I think the research has established in a way that the legal professional identity, for better and for worse, kind of serves as somewhat of a prophylactic, for want of a better term, for re-traumatization. I mean, Sarah Nucky and Meg Satterthwaite have done research on human rights advocates and trauma that they suffer, and have kind of found that the human rights lawyers are less likely to suffer trauma. And they hypothesize that it's the clarity of role that might mitigate, I suppose, what they describe as kind of the perfectionism or the kind of dangerous cynicism that might emerge that creates burnout. Now, I say this at the start because there's a bit of a paradox here. In some ways, I think it is our professional boundaries at times and our clearly defined professional role that actually helps to re-traumatize our clients as part of their process and journey through the legal system. So there's a bigger politics about our self-care versus the care of our clients as well that we need to be aware of. I think practically there's some workflow issues. I think we need to be aware that it's not simply people kind of immediately interacting with, for example, traumatized clients who are going to be victims of vicarious traumatization. Again, the literature clearly establishes that it's often, in fact, people who are more distant from those direct encounters that are going to be re-traumatized. So it can be office staff who are processing bundles, who are organizing supporting materials. And it's the lack of direct contact in some ways that makes it very difficult for them to process. So from a concrete workflow point of view, I think we need to be aware of how and when and who does the work. Organizations often have rules around doing some of this work by yourself, not doing it by yourself, not doing it late at night, not doing it as the last thing as part of a day. So thinking about within organizations and teams how work that is potentially traumatic gets done. And then I suppose I think we need to make, as much as I like the agency that self-care gives us each, I think we need to make well-being more of a collective task. I think we need to adopt the feminist idea that the personal is political, and we need to recognize that kind of the trauma that our clients and that inevitably, vicariously, we are having to deal with is part of the systems of oppression that we are in our representation of them trying to fight. And so we need to adopt collective approaches. I mean, bluntly, it's often the effects of trauma internalized within organizations that can make them quite toxic places to work. If you look at the literature on well-being within the human rights sector more generally, the immediate vector of harm is rarely the encounters with clients and immediate victims of human rights violations. Is rather played out by organizational structures which have kind of suffered because of the trauma of dealing with these accounts and kind of become very toxic. So I think we need to bring the discussion about self-care and make it more of a collective discussion and bring it into a broader understanding of how we can have kind of more healthy workplaces.
I'm mindful of how quickly this session is going, but I do want to make sure to ask Zoe if you have any further insights into this question. And then if possible, a very short question for Oliver and Jack before we move to question and answers. So Zoe, any further insights on this question of self-care?
I think I might disagree with the literature that human rights advocates are less likely to suffer trauma, and I would see that effective self-care is actually an essential part of human rights practice, as Martin did identify, but also it doesn't stand kind of separately from the care of our clients. It's not possible to advocate effectively for our clients if you don't also take care of your own well-being. And so there are a number of steps practical steps that can be taken to address that. I mean, firstly, it's around having awareness of the vicarious impact of the work, and there's lots of literature on that. It's about having an active prevention plan, so a plan that considers your self-care across a number of relevant domains. And I know a number of colleagues also train on this, but therapeutic organisations like Freedom from Torture and the sector organisation, Immigration Law Practitioners Association, do training around how to develop that work. It's around accessing support when you need to, and again, organisations like Law Care offer really effective, useful support. And I would also echo what Martin said around the importance of addressing this collectively. Many of our institutional practices kind of cut across the importance of promoting well-being, and it's really important that as organisations we address these collectively and show leadership. That there is something around the kind of heroism of human rights practitioners that has historically made it difficult for these practices to be embedded. But as I've practiced over a long period of time, so seeing people disappear from practice, or judges and others who see a lot of trauma day in, day out risk becoming case hardened. It's really important to embed these practices, and there's a range of resources that are there to support practitioners whilst but the sector more generally addresses this also.
Great. Well, if we could very quickly have one last question that I'm going to direct towards Oliver and Jack. And this, I think it's important to recognize that with any trauma-informed advocacy, paying attention to cultural sensitivity is key. So what role should cultural sensitivity play in trauma-informed advocacy, including in your practices, such as in cross-examination? So I know we have just a few minutes. If you could just quickly answer that, give any thoughts. Oliver, could we start with you?
Sure. I'm just going to briefly address the point of cross-examination there, because of course, like I say, I act for claimants and defendants, and there will be advocates acting for defendants as well. And if that is your job, you have a duty to act for your client without favour to the best of your ability, which can present really difficult conundrums and ethical issues, given that you also have obviously a strong moral obligation not to re-traumatize the individual who's at the heart of the case. That said, if your client's case is that what the individual is saying is wrong, is factually incorrect, you have to put that case. And you have to put that case sensitively, you have to put that case appropriately, but you would be neglecting your professional duties if you do not put that case. And so that leads into, I think, some of the points that Zoe and Martin were just discussing, but from a very different angle, which is that it can be very personally challenging to be the advocate for the defendant, cross-examining and having to put very difficult points to the individual in question. About how to deal with that in practice and how the courts deal with that in practice, I just want to raise two quick points, both concerning the joys of procedure, because as we all know, procedure is very important here, and practice directions. There are in fact two practice directions that are particularly relevant here that all practitioners should be aware of. The first is in the family court, practice direction 3AA, which makes provision for how to deal with and how the courts should address vulnerable witnesses. And this is, like all practice directions, and as I think Zoe just mentioned earlier, as these are points that the judges have to be aware of, it's particularly important for you to be aware of them too. And the second is the practice direction in the first tier tribunal and upper tribunal, where lots of these asylum and immigration cases go, of course. And that's the practice direction for child, vulnerable adult, and sensitive witnesses. And so you should really be thinking, does the witness need to give evidence? If they don't need to give evidence, then they shouldn't be doing so under these practice directions. there's provisions for breaks. They can give evidence via telephones. They can give evidence via video link. They can have an appropriate adult with them. So the tools are there, whether when you are cross-examining or whether you are acting for the individual in question, to make the experience, to make the whole process as sensitive or as reasonable as possible. They're not the best in the world, as I'm sure everyone is aware, and as I know Martin has done lots of work on in particular. But they are something that if you are practicing this area, you should use what you can. And so at that point, I'm going to stop talking and hand over to Jack quickly.
Jack, if you have any thoughts before we move to a few questions.
Very quickly then, just 3 quick tips from perspective of working with clients. Again, reiterating the need for ground rules meetings. Your job is not just to present, it's also to inform and advise. And a client who understands the process, who understands what's expected of them and the roles and responsibilities of their advocate themselves, is more likely to be able to overcome any barriers to do with, say, cultural issues of deferring people in positions of power. If that's explained to them at the outset, they'll understand what's expected of them. Second issue is de-escalation techniques. There are techniques that transgress cultures, things like asking them about food and asking them about their children, things that are common to the human experience tend to be more useful for de-escalating conversations. And then finally, don't be afraid to push. If there is a need for your client, then ask for it. And it's easy in the moment to fall to the pressures of funding, of the courts, of the timeframes, but ultimately you have to act in the best interest of your client. If you need to adjourn, apply to adjourn. If you need a single gender court, make sure that's done. And if the client is going to change their instructions, make sure that it's an informed decision, that you have given them information on, and that they know the consequences of going for it or not going for it.
Thanks, Jack. Okay, so we have only a few minutes. I've been following the questions and have seen that some of them involved questions about any other resources or trainings that anyone can undertake in order to help develop their trauma-informed practices. And I know that our speakers have been addressing that along the way. There was one question that I'll read out just in a moment, but I think with our final moments, perhaps I can present this question and then just ask each of our panelists to weigh in on it or give any last thoughts before we close the session. So the question is, do you have any advice for representing people who have suffered trauma but are incapacitated due to disability or mental health conditions that could affect how they express themselves? So if you want to, I'll start with Zoe, if you want to weigh in on that, or if you have any final thoughts. Also, the question of if there's any ways that the legal system can support trauma-informed practices, and if there's any way that changes can be made in the system as well. Any thoughts on that as well? So let me hand it over to you for your last thoughts before we close.
Great. If I could also add, just to the previous discussion on cultural sensitivity, we're often working through interpreters and making sure that interpreting is precise. And I was involved in a piece of research which identified that there are a lot of languages where there just aren't the words to describe some of the abuses that we're often requiring to just talk about in our practice. So discussing with interpreters in advance, making sure there aren't gaps, and also looking after your interpreter afterwards. We need to use them as a kind of translating machine, but they're not, and they often also have to process very difficult material. In terms of incapacitated, that covers quite a broad spectrum of practice. I work in issues of where people lack capacity, and there's quite a lot of guidance around assessing capacity, determining the extent to which people are able to make decisions in terms of understanding, retaining, using or weighing relevant information to make decisions. So that's sort of quite a large area of practice that that there is quite a lot of materials in, not least the Law Society itself has guidance on for solicitors on capacity, which is a useful starting point. Obviously, before you get to that point, there's a process of providing sufficient support to enable people to make decisions around their case as far as possible. And then and around that, it's looking at, I suppose, the individual and any surrounding materials you have in terms of expert reports that can provide guidance. And one other point that in terms of institutional practice is one of the things we're often, when we're instructing experts, it's to ask them to comment on people's communication needs and abilities, so that we can be informing the court of that, and so that that can be taken into account by the court in the assessment of their evidence. That's a quick answer to a very big topic.
Thank you. Martin, can I come over to you? I think we just have a few minutes, maybe a minute from each of our speakers. I know that's a tall ask, but Martin, if you have just any last thoughts.
Yeah, just on this question of how we can make the legal system better support trauma-informed practices, I guess the observation is just that we are the legal system at the end of the day. And so having this conversation is part of making the legal system better support. And so that's the first thing. And I guess the other thing I would say is, I think we need to, I mean, we talk often about mainstreaming discussions. I think there's a very concrete benefit in mainstreaming this conversation about trauma-informed practice, in that, I mean, I think the psychological literature suggests that the people best able to respond to trauma are people who adopt diverse coping mechanisms. And I'd suggest that the same is probably true of us as a legal profession, that the more diverse and inclusive that we can be, the more we will develop a range of coping mechanisms, which then will both individually and collectively help us better respond to the issue of trauma. So I think kind of encouraging the diversity and encouraging the further conversations about this topic, I think, is really important.
Thank you. Jack, any last thoughts?
Yeah, very quickly on question 1 is, remember the limitations of your role as well. As the lawyer, as the advocate, you are not there to do everything. And there are other roles that you can bring in to serve other interests of the client. With children, we often work with responsible adults to make sure that there is someone protecting the child's interests, so that you can focus on the legal side of things. Use doctors, use intermediaries as necessary for people who might have greater difficulty above and beyond a certain level of trauma. In terms of what we can change, there's a discrepancy between how we handle trauma in different practice areas. If you look at how a Home Office interview is conducted compared to how we might question a victim of sexual assault in the criminal court, and they are night and day to each other. Some consistency of best practice, I think, is something that we can try and work towards. And you know, the legal process in itself can be therapeutic. A lot of my clients who have suffered trauma like to go through this process. It's cathartic for them. There is scope within this process for people to use it as an act of healing, in a way.
Thanks. And finally, Oliver.
Very quickly, just on the question of how to effectively represent people who struggle to express themselves. I can't remember who asked it, but it was in the Q&A chat. The best advice I can give there is to talk to them and also talk to people around them. Talk to their family, talk to their friends, talk to social workers, talk to any charity workers that they've been engaged with, because those people will have real insight into that individual's experience, even if they can't express it themselves. And in an ideal world, they would then also be providing evidence as well.
Well, wonderful. I think we're going to have to wrap up this session. I know we've gone a few minutes into your break, but I would just want to extend a very just thank you so much to our speakers who have generously shared their time with us. And with that, we're going to take a 15-minute break. And the next session will be starting at 2:15. It's session number 4, which is on compassionate and constructive client interviewing, which will be chaired by Vice Chair of the Human Rights Lawyers Association, Shoaib M. Khan. And thank you all so much for joining and for interest in this topic. I know much more discussion is needed. And see you shortly at the next session. Thank you so much.
Good afternoon, everybody. I hope you can all see and hear me. Thank you so much for joining us today. And I can see we have all our panelists here already. I know obviously we started the break a bit late, but hopefully everyone is back and ready for session 4 for today. So firstly, thank you so much everyone to our speakers and for all of you for attending. I hope you found the session so far to be useful and enjoyable. I'm delighted to welcome you now to our session 4 for today, a discussion on compassionate and constructive client interviewing. And we have a wonderful panel for you today. You will be familiar with the format by now. So the plan is obviously for the speakers to have an open discussion first, and then hopefully we still have time for a question or two after that. We obviously have very limited time for each session. So I will go straight to our panelists now. So they can tell us briefly about themselves and their work. So hopefully all the panelists are ready now. So can we start with maybe Samia Yaqub? She is a member of the Wellbeing Group at ILPA, the Immigration Law Practitioners Association. So Samia, if you can tell us a bit about yourself and your work.
Absolutely. Afternoon, everyone. Thank you. It's been an absolutely amazing session so far. So a little bit about myself. I've been practicing immigration law for over a decade. My work's covered a broad range of asylum, complex family matters, and then more recently economic migration as well. My journey in law within immigration law has been deeply intertwined with a commitment to look at the compassionate and constructive way of our interactions, not only just with our clients, but also with our colleagues. I've been a proud member of ILPA's Wellbeing Group, which has been crucial to supporting practitioners within their well-being and looking at the psychological strain caused from assisting vulnerable clients and the traumatic situations that they've been through, as well as kind of supporting practitioners during external pressures, such as the recent hostility and anti-migrant rhetoric, which we had earlier this year. And ILPA's Wellbeing Group was critical in creating a safe and supportive space for practitioners where they could feel they could come and have that support during those strenuous times.
Thank you so much, Samia. Our next panelist is George Grammer-Taylor, who is a trainee solicitor at Clyde & Co. and an academic committee member at the client interviewing competition for England and Wales. So, George.
Thank you so much. So hi, everybody. My name is George Grammer-Taylor, pronouns he, him. As introduced, I'm a trainee solicitor at Clyde & Co., currently sitting in the professional indemnity team. And the reason why I'm here today more so than anything is my involvement within the client interviewing competition for England and Wales. So by way of background, I studied for a law LLB at the University of Sussex from 2019 to 2022. In my final year of my university degree, I entered the client interviewing competition regionals, and also internally at my university. I was partnered with a lovely girl called Sam, who's based now in Canada, and we just kept progressing through the client interviewing rounds until we won the international competition. We represented England and Wales in the international competition. So all of that experience I now use as my role as an academic committee member, but also within my client interview I do as a trainee solicitor. I found that particularly with client interviewing and the compassion behind it, it's always important to have a people first approach in law, and I was recently recognised on the O-List 2023 for that reason.
Amazing. Thank you so much, George. And our third speaker is Josephine Fathers, who is a barrister at Garden Court Chambers and a member of the Executive Committee of the Bar Human Rights Committee. So, Josie.
Thank you very much, and thanks very much for having me. Yes, as was said, I'm a barrister at Garden Court Chambers. I predominantly practice in immigration and public law. I'm on the junior end of the profession, so I became a tenant from pupillage last year, and that means that my practice today is very heavily focused in the tribunal, and that in itself is very varied. So includes protection appeals, deport appeals, human rights, entry clearance, all of that kind of stuff. And so the perspective that I want to give is from someone who's working in the tribunals 3 to 4 times a week at least, often in highly time-pressured circumstances, and working with really, really vulnerable clients. It's a real privilege to do that work. In terms of my own journey to the bar, I worked for a number of human rights organisations, including BHRC. Before I came to the bar, I took my time, and I also did some freelance legal research before that. So yes, thank you very much.
Thank you so much, Josie. Okay, firstly, if I could open with a general question on this topic for all of you. So basically, what techniques or methods can lawyers be using to build trust or rapport with clients during interviews, particularly initial interviews, perhaps when the relationship obviously isn't that strong, particularly when clients may be feeling vulnerable or hesitant to share their experiences, or indeed any interviews where clients might become emotional or distressed. So, so what are our panel's views on that? So maybe I can start with Samuel.
Yeah, I think this was touched upon slightly in the last session, but I think the intercultural communication is absolutely key. And when you are approaching your client in that initial stage, not looking at it with a narrow lens that sometimes from the West we can do. So we may kind of see their body language as very closed, but that may just be because in that culture, that's how maybe a woman is expected to be. There's an expectation there. So I think that's, for me, that would be one of the most critical things. Looking at them as an individual, maybe doing some background research prior to the interview to understand the cultural kind of differences. So you can pick up on those small cues and where, if you miss something at that stage, it could be quite critical later on in their case. So yeah, I think that for me, that would be one of the key things.
Thank you. Josie?
Yes, so I think there's two aspects that I would bring up. The first being is really think about the environment in which you're speaking to the client. It might be that you're working with someone who's had really difficult experiences, including perhaps being trafficked, being placed into very small confined circumstances. It's really important to think about the overall environment in which you're seeing them. Ideally, that would be in person. But for example, if I have someone coming into chambers, I would want to make sure that I'm using a larger room as opposed to a small room, just to avoid any sense of being confined or bring up any other difficult experiences. The second part is really about making sure that there's enough time to break the ice and to talk about things that aren't difficult early on. So not immediately talking about the topic, making sure that they feel comfortable. A tip that I picked up from a colleague would be to speak about anything in which you find some common ground. And the way to do that, or one of the ways to do that, which I thought was actually quite a good way, was, for example, to get your client to come and help you make a cup of tea, just to make sure that the environment is comfortable for everyone. Just talk about, general things that might be relevant. The weather, it could be anything to make that person feel safe and feel like that it's not an intense meeting, and particularly in the immigration context, the circumstances in which they will have been interviewed before would have been during the screening interview and the substantive interview. Those are particularly difficult in themselves, and so you want to just create that environment to demonstrate that it's not the same, that we are on your side, you're here to tell us so that we can present your case in the best way possible.
Thank you. And George?
Yes, so I believe both panelists have covered most of what I was going to say, really. I guess the only thing I would say is to note that some initial client interviews, some of the interviews that you'll be engaging with the clients is just for one-off pieces of advice or assistance, and sometimes it's a continual assistance. So I think the approach can be had that obviously if you are having just kind of like one-off initial advice, consultation, or appointment, it might not be best just to get go too far into it. Just keep it nice and just friendly, amicable, like Josie said, maybe just go make a cup of tea. If it's more continual, I would say I had a client in Atlanta, and it was really useful and helpful to always address them by how they would be preferred to be addressed. This person just preferred their shortened first name. And that meant a lot to them because it humanized them. It made them feel like they were human. Often people who seek legal advice often feel that they are there's a power imbalance, or there's like there's a step that the lawyer or the advisor is normally a step above them and they're kind of looking up to them, and the lawyer's looking down on them. But actually, we are all just human beings. And I think one bit of advice that I was given very on in my legal journey was just to humanize the process and treat everyone as equal, no matter their position, no matter their background. At the end of the day, you are the same. And I think another bit of advice that I was given to build trust and rapport in particular is to always acknowledge that you will never know what someone's been going through, but you are there to listen to what they've gone through. I think sometimes people feel like they go, oh, I know what you're going through, to feel that to compare and to kind of gain that rapport, but actually every person's journey is different. So a real big tip there is just to ensure that you say that I can't relate to this, but I can listen and help, understand. And last but not least, always a good tip, if you are inviting someone to your space, it's always good to have a box of tissues somewhere in the room, just in case they require them.
Thank you so much, George. Yes, I mean, following on from that, and I guess another important question considering the topic, I think, but how can we balance empathy and professionalism then? Obviously, we spoke about, we have to treat them as people, we need to be listening to them, but how can we basically balance that with our professional role, basically showing compassion, but in a way that objectivity and the effectiveness of the interview is not really compromised. So Josie, maybe?
Yes, and I mean, there was, as I said at the beginning, there was an aspect, particularly to the previous question, it's relevant to this question as well, as to how do you do all of that in circumstances which I often find myself in, which is I'm meeting the client for the first time on the day of the hearing. Ideally, I would have spoken to them before. That isn't always possible. And how do you balance those kind of time pressures of having to get through the really important bits of advice and preparing that person who's about to go into a hearing, while being compassionate and making sure that you have a constructive meeting, and that can be really difficult. And that's also relevant to this question as well, in terms of how you balance that empathy at the time with the professionalism of everything is chaotic. There's so much going on. You've got to try and engage with your opposition as well as with your presenting officer, as well as with the court clerks, all of that kind of stuff. You've got to make sure that your client is there and feels comfortable. So that is a difficult one. And I think in those circumstances where you do have that time pressure, you do have to put more emphasis on the professional side. Obviously, you've got to comply with your professional obligations just as a basic rule, but you also have to make sure that the client is fully prepared, and that is difficult. So you have to go through those non-negotiable things when you're talking to someone who's about to go into the hearing, breaking it down in a way that is simple to understand, particularly when you're speaking through an interpreter, making sure you have those building blocks of your advice, which is applicable to most, obviously adapting it according to each case, to make sure that they feel that they know what's going on, because the most important thing, especially on the day of a hearing, is that the person, the client, it's their case, they feel that they are fully involved and they know what's happening, and it's not just they're having words spoken at them, they're being talked about throughout by lots of different people. So you have to find that balance of being able to get through everything that you need to do in a way that doesn't alienate that person, and that you're just not talking at them at a million miles an hour in the 10 minutes that you have before the hearing. So that does mean that what I do is signpost everything I'm about to do, explain why we need to get through it, why it's important. I also, if I have to, I will cut a client off, which is difficult. You have to know how to do that in a sensitive way, and you have to also know how to do that in a way that portrays confidence, that I, as your barrister, I know what your case is. I've got the papers. I know what's happening, and I know that these things are really important. But we are in this situation, and we do need to make sure that we have everything ready to go. So you have to be able to do that in a gentle way, while reassuring them that so that they can have confidence in you as their representative who's about to go and speak for them. And I think related to that, my thinking of someone who is in that situation, that they would prefer to have an advocate who is able to put their case forward, as opposed to an advocate that is there just to feel sorry for them. So that's why the kind of balance towards professionalism kind of comes in on that way. You will often have someone who feels unheard, who is vulnerable, and they feel alienated by this complex process that's going on around them. So by trying to simplify that, getting through it in that time pressure allows them to have that confidence in you. And I think that overall is part of it. It's a way to make someone feel much more comfortable with this really difficult process and disorientating process that happens particularly on the day of a hearing. So I would tip the balance slightly towards the professional side with both, particularly on the day. But of course, it really depends on when you're speaking to the client and in what circumstances that you're speaking to them in.
Thank you so much. All very helpful advice. George.
Yes, not much to say. That was a really fantastically pertinent answered. I think the only thing I would say is the way in which I guess you would kind of remain professional and ensure that the interview is being effective. I think I would echo what Josie was saying in regards to learning how to cut clients off in a way that works for you. When I first started doing client interviews, it's very hard to like kind of like put a halt to kind of digressing off what you're looking to do in an interview or what you're looking to do in a conversation. So I think that would be probably a tip that I would echo, is just to kind of find a way in which maybe just practice with your friends, or practice kind of, you know, when you're at home, just ways in which you can find different ways to kind of steer the conversation in the right way, or kind of just, you know, put a halt to what's being said. I think another way in which it's also is that I think this is something which kind of you develop throughout your legal career, is it's encompassing your professionalism, but also your authenticity. So the way in which you approach people and the way you talk to people is completely your own style, and it's kind of authentic to you. And that may change over time. The way in which I used to do interviewing back when I first started, is, you know, started learning how to interview, to now where I am now is completely different. I feel personability goes a long way. It makes people feel comfortable, but I think you can be personable and also professional. The only thing I would just say is just always remember that most of the time, whether it's in a fee-paying environment or it's a pro bono environment, irrespective of fee, it is a professional service. So just try your best to make sure that you're talking to this person with respect, talking to them with an open mind, and most importantly, talking to them in a, I would say, a way in which, as I touched upon before, in an open-minded way, to all sense of personal characteristics, you know, race, culture, sexuality, gender identity. I remember interviewing a particular client where I simply just asked about their preferred pronoun use and introducing my own. That really meant a lot to them, because this particular colleague was trans non-binary, but they weren't outwardly presenting towards that, or even wanted to discuss that. Sometimes invisibilities can be meaningful to people, and I think just go into client interviews with personability, but, you know, sometimes just recognizing that being open-minded and careful and conscious of your language makes a big difference. You know, you're not talking to your friends, you are talking to clients, you are talking to people who are seeking legal advice, and often people that I've worked with have never had legal advice before. They are the most vulnerable in society. They are the ones who, you know, kind of like fall on every word that you say. And I think the way you present yourself in that initial steps and those initial interviews goes a long way. But just to echo once again, just to kind of round up my point, you can be personable, you can be authentically yourself, but just be conscious of the language that you're using, because the words you say do mean a lot to those who you're talking to.
Thank you, George. I have to say, interesting. I mean, George's tip of the day, practice client interviewing by cutting off family and friends, just as practice when you think they're digressing or going on for too long. Samia, so I mean, obviously I'll bring you in on that as well. But just another question, if you could answer that as well at the same time. So what sort of practical or well-being strategies do you think that lawyers can use to manage the emotional demands of clients, obviously, during interviews, while also, you know, navigating the dynamics of a professional relationship? So if you could just address both things.
Yeah, I would separate these into 3 different areas for myself, and then I'll kind of go into each. I think the first skill as junior lawyers is really important to learn is setting clear boundaries. And this can come in many different forms, from your own time management and workload management, and knowing when to say it's too much or I can't take any more on, to avoid burnout. Also within this category is emotional detachment. Whilst George said they are clients, sometimes as lawyers working in these fields, we're natural empathets. So we will always take on a bit more than somebody else. But it's making sure that you keep that boundary and not take the burden of the trauma onto yourself. And then also compassionate detachment, that works really well with clients. Whilst you hear them, but you don't absorb their pain. And it's not easy. I remember initially when I used to do asylum cases, it was really difficult to just switch off at the weekend, because you'd kind of think about the story, and it's just, you know, some of the stories are unbelievable what people have been through, but you do have to learn to just kind of park it, and it is work, and it's so hard to do, but it does come with practice. Setting realistic expectations, managing your clients' expectations as well as your own colleagues, and where you're liaising with counsel. I think it's really important to build that relationship up from early stage, so that when someone like Josephine is going in, they are briefed up from an early onset. And I think they just, where you do that with counsel, they appreciate it, because it makes their role a little bit easier when there is so much going on the day of a hearing. It just means that they're briefed in, and it just makes it go a lot more smoother, I think, and that puts the client at ease as well in that case as well. So that's the first group of strategies. The second, I would say, practice self-awareness and emotional intelligence. And I don't think we talk about this in our profession enough, whilst it is starting to surface, but knowing ourselves and knowing our own triggers can be so important, and having emotional check-ins, whether that's with a colleague or, you know, yourself through something, journaling at the end of the day sometimes helps, just getting it all out of your mind. Mindful techniques. People have this kind of taboo that you have to go off and sit in a particular room on the floor. You don't. You can just take a moment at your desk and say, right, I just need to pause. This is just too much. Go make a cup of tea. Just take that break and give yourself that breathing space when it feels it. Because some of these cases can. And sometimes you'll get a case where you get a blockage. I've had it so many times. For some reason, you just can't get the submissions or the witness statement. You just can't get your head around it. And going off and having a conversation with a colleague, it just can help so much. So giving yourself that permission to take the breaks and checking in with yourself emotionally, and seeking counselling. Again, you know, it's something that we don't talk about enough. Sometimes you don't realize how much you've taken on, and you need that professional support just to help yourself. You know, and we don't want to lose lawyers. And I think sometimes taking that pause, or recognizing that if not in yourself, sometimes within your colleagues, if their behavior changes all of a sudden, having, you know, taking them to the side and checking that everything's okay and something's not stressing them out within their work. And sometimes personal life. And the last one I think is really, really important to me, because over the years it's really made a difference to my practice. And that's finding someone that can mentor you, someone who's got that experience, has, you know, tread the path before, and almost it becomes your safe space where you can go. And usually it's not within your own law firm or chambers, it's someone external that you've found. For me, it was a barrister who was much older. She knew, just you'd say things and she'd be like, I know. And that was just enough. That was just simply the fact that you didn't feel alone all of a sudden, because it can be quite isolating, and having that peer support can be so essential, working, you know, in this area where there is so much trauma, so much emotion that's going on. And then as a whole, as companies, as chambers, as support networks, I think creating supportive environments, working collaboratively, you know, and knowing how we can make it all just a little bit easier for ourselves. So yeah, I think those are the three kind of broad, I could go into this so much more, but in the interest of time, I think that's how I would split the support units out and strategies to help.
Perfect. Thank you so much, Samia. So another question now, I guess, mainly for Josie, perhaps as the barrister on the panel, but maybe from the other two, from the other side then. So how do you think that barristers and solicitors can effectively communicate with each other to ensure that client interviews or any information being obtained from the client actually yields the information that we need, and that the barrister is eventually going to use, while again also maintaining a compassionate, sympathetic approach. So maybe we can start with Josie and then see what the others have to contribute. Josie.
Sure. And I think before I kind of go into that in a bit more detail, I do just want to follow on from what Samia said. I mean, when I was first looking at the types of questions that we might be answering, when it came to well-being, I kind of put, well, if you know the answer, can you let me know what it is? And I found that incredibly useful. So thank you. And I echo all of it. Some of the things that I wanted to add just from the barrister's perspective. I mean, being a barrister can in itself be quite isolating. Obviously, you're generally self-employed, you're doing your own cases. I mean, I certainly find I have the support of colleagues, but it's very different to working with work colleagues in the kind of the normal sense of being employed. Those that I see around me who really do have a good balance when it comes to well-being, find a good pattern that works for you. It's the general things that you might be advised in this sort of area, but take up a hobby, get a pet, invest in your family life. It's when I look at my colleagues, it's those who really give themselves the space to have that private life, that means that they can effectively balance the work that they're doing, because it is difficult. It's so easy to slide into burnout territory, and it's so easy to do that really early on, particularly when you're taking on so many cases and you're balancing being self-employed and the money issues, frankly, that come into it, particularly when you're working in legal aid. So that point that you made, Samira, in terms of being able to read yourself, I think is really important. It's something I'm certainly still learning. But you won't be doing any of your clients any favors if you are not able to work at your best. You won't be able to put their case forward. You won't be able to concentrate on things properly. And I mean, next to burnout, there's vicarious trauma. There's also becoming case hardened, and I think that was mentioned in the previous panel as well. And it's so important. You have to be able to maintain your objectivity, but there is an emotional side of this job, because that's part of how you give your best advocacy, is being able to draw out those facts and everything that's happened in the best way. So if you become more and more case hardened, you won't be able to do that effectively. So recognizing those stages of burnout is really important. And I think this was also mentioned in the previous panel. One of the things that I try and do, it's not always easy, but you have to remember what your role is and the limitations of that role. In the circumstances that I work in, well, in all circumstances, I'm not the decision maker. You're not the decision maker. And there is a tendency, or there can be a tendency, and again, I think this was raised, to have a saviour-like approach to these cases. And I had a colleague in Chambers say to me that you are not the saviour, not directly to me, I should say, just generally speaking, you are not the saviour, and the road to hell is paved with good intentions. So as well-intentioned as this work might be, it's really important to remember the limitations of your role and what you can do. Particularly, I think, for someone who's working in a role like mine, when you're on the front line of the court side of things, you can really feel like it's all on you. If something doesn't go right, that's because of something you did. And of course, everyone has to have a reflective approach to their practice. Everyone has to do the best that they can. But there's so much going on that is beyond your control. And so your focus just has to be on you and doing the best job that you can, preparing properly, and all of those things that were said before. So that was just what I wanted to add in terms of the well-being side of things. In terms of barristers and solicitors communicating effectively with each other, I mean, one of the things that, again, Samia said was early stage briefing, and that was the kind of number one headline point that I wanted to raise as well. I mean, I've mentioned it, I do quite often find myself being instructed towards the end of a case, and that makes it really, really difficult for a number of reasons. There's a reason why we have these two strands of the profession. We need to work together as a team and as a partnership. And one of the things that a barrister can bring in, and it's not because that barrister is, particularly special, but it's just because they're looking at the case from the top down almost with that independent perspective. They haven't been involved in all of that case building and all of that incredibly difficult work that goes into that, but they have that difference in perspective that they can bring. And that's so important in, if I'm looking at a protection case, an asylum case, when you're coming towards the witness statements and filing the evidence and all of that sort of thing, I do find when I haven't been involved at that stage, it's so difficult to then fix something later on, and all of that can have really negative consequences for the case as a whole. So I think early instruction is really key, and particularly before evidence is filed. That's the kind of the main thing, and that's the main point that I would want to focus on. And the reason why that's important, I've already mentioned it, but in the immigration context, in the asylum appeal, I don't do that much witness handling. The client's evidence and evidence in chief stands within their witness statement. The majority of the evidence that they give, the vast majority of the evidence that they give, is through questioning from the Home Office on the day. So it becomes very difficult. My job is limited in that sense. There's only so much that I'm able to do in terms of the witness handling and things like that. There's obviously ways that you can manage it, but that's why it's particularly important to have that early instruction from the barrister's perspective. But for that to be any good, you have to find ways to work in partnership with your with those who are instructing you. And that from the barrister's role is making sure that you are available, that you're responsive, and that you are clear in terms of the best channels of communication. So I can find, for example, it's great to get a really detailed email of everything, and I will get to it, but there's lots of other things going on. If it's something that would really just be something that's very quick, then I'm always available on the end of the phone. And so it's about, for me, establishing those lines of communications in order for to avoid any blockage from my end, if there's something that's waiting from my perspective on it. So yeah, being responsive, and just generally for everyone to recognise that this isn't a hierarchical relationship. We're working as a team. There's distinct roles, as I've already kind of outlined, but we're working as a team on this case. So it's a linear relationship, and so trying to kind of develop that with your solicitor is really, really key. And linked to what I said about the phone, I'm instructed on really a lot of cases, and quite often my interaction is just via email, and it's kind of faceless emails, and it can get a bit confusing. I find that even just having a 2-minute phone call just to say hi, and just to hear someone's voice, that immediately creates that connection with what that faceless email account is on this case, and that just makes it so much smoother moving forward.
Thank you so much. Just before we go to the others on the same question, just a reminder that it is now time for Q&A. I can't, I think, see any questions so far, but unless I'm missing something. So if you do have any questions, please ask now, so that hopefully if we have a few minutes at the end, then we will be able to get to those. So can I come to George then, maybe? George, anything to contribute, mainly on the barrister-solicitor relationship, or generally just running a case with a colleague?
Yeah, I think, I can kind of maybe just touch upon points which are kind of like pre-instruction and also kind of during instruction. So I think something that as a junior in my legal career, I think a good point is about request for availability and communicating that entire availability for the instruction. So what I mean by that is, if you are seeking assistance from a barrister on your case as a solicitor, you need to ensure that you've thought of the availability for kind of what you require it. The amount of times that I've kind of just witnessed, supervisors forget things. Oh, actually, we need them for this day, or we need them for 3 calls prior to this day. So I think there's to respect the barrister, but also effectively communicate, ensure that you have all your dates of what you require the availability for, and also have a flexibility when you are instructing barristers. Barristers are very busy people, and often they are inflexible with there's hearings going on, etc. So as a solicitor, just have that kind of approach where you go to the clerk with more than one date. And I think something which I find is quite useful is effectively communicating updates. Often when a case is progressing, you often receive updates that can be communicated through to the barrister. Often I found as a junior, when we received new documentation that was relevant to an upcoming conference, or for example, if we were, for example, pursuing a fundamental dishonesty claim, and there was something which we weren't too sure on, we'd often seek counsel advice. So just maintaining and upkeeping a strong communication line, and also respecting the fact that, you know, sometimes if a barrister has to go away for a 2-week hearing, you may not get those answers straight away. So just keeping in constant communication and just respecting that your availability may not always match a barrister's availability. You just have to have that kind of flexibility to it.
Amazing. Thank you so much. Samia.
I think, should we move on to tips for, I think we're at almost time. So my tip for the day would be taking care of yourself is not a luxury. It's absolutely essential so that you can fully show up for your clients, for yourself and your colleagues. A well-rested mind is going to, you know, be a lot more effective than someone that's on the brink of burnout. So just take care of yourself and try to embed that from a very early point on your of your career, and yeah, it will do wonders.
Thank you so much. So just, I mean, quickly, we can take one question. I see there's a few coming in now. So firstly, if any of you have any ideas, are there any resources or anything out there that someone can reach out to just to learn more about client interviewing? Is there anything any of you might have used or something that helped you? So I guess whoever, Samia, since you're here. So yeah, do you have anything in mind?
So resources wise, I would say Law Care, absolutely. So do some brilliant supportive stuff around this. ILPA has a wellbeing resource on their website. We also have a monthly wellbeing meeting that is open to everyone. You can come, it's a safe space as well. And also they do some training as well around vicarious trauma. Vulnerable clients as well, so that's just close to where I am, so I'll just highlight those and give them a plug. So yeah,
thank you. And George, I mean, of course, obviously the I'm sure you said the client interview and competition, but any other resources, anything else you can think of, something that might have helped you, or indeed as part of the competition, anything that you went to learn more about client interviewing?
Yes, so two approaches. One which is more formal than the other. I guess the formal approach is going onto YouTube and watching client interviewing mock interviews. Previously the LPC, now the SQE, but also the bar course do mock videos that you can watch and kind of try to emulate. Which I found really useful as a formal like training resource. And it kind of there are tips there about how you can make it personable, make it a meaningful conversation as opposed to just quite a static, uncaring interview. And in a more informal, fictional sense, The Good Wife. I watched The Good Wife a lot. There's lots of client interviews on that series, and one of the lead characters is a very compassionate individual. And when I was first starting my legal career, I found that to be quite an inspiring thing to kind of follow, just bringing yourself and that kind of caring nature towards interviews. So depending if you want formal or fictional, there we are, the two options.
Perfect. Thank you so much. Josie.
Yes, so I think working with vulnerable clients, it was mentioned before, look at all the practice directions. There's a wealth of resources on ILPA as well as LAG, and there's lots of information available. For me, what has and still is a goldmine in terms of navigating the kinds of cases that I do, and in particular making sure that you get everything, or that you're communicating everything that you need to the client and ensuring that they are best prepared, is on the EIN website, the best practice guide. That really spells it out for you, and I've really used that in my practice. I use it almost daily, so that would be my recommendation.
Thank you so much. And then one question, I guess, specifically for Josie, mainly a question that came in about the difference or how it might be advantageous for a direct access barrister. So again, I mean, I guess they're talking mainly about obtaining information from clients or the client interviewing. So would it help if you're a direct access barrister?
So it's difficult for me to give that perspective because I'm not a direct access barrister. Obviously, you would have, if you are being instructed directly by the client, you just have a lot more, you should have a lot more contact with them. And so you would need to be involved from the beginning. That does in itself, it could cause problems. You know, there's, like I said, there's a reason why you would ordinarily have a solicitor and a barrister, not always, but yes, I mean, if you are doing direct access instructions, then you need to be kind of fully au fait and aware of those techniques that we've discussed in terms of when you're initially taking those instructions for witness statements and things like that, because that ordinarily the barrister might not be involved in that process.
Thank you. And a question, again, it came specifically for Josie, but I guess really quickly we can ask the others from the point of view of their roles as well. So mainly, are there any inherent qualities you believe that would make managing the emotional workload of the work that we do easier? So do you think there's any personal inherent qualities that help? So Josie first, perhaps?
I don't know. I mean, I would go back to something that George said in terms of being personable but professional. I think in order to do this job, you have to be personable. You have to be able to speak to people with dignity. You have to be able to speak to people as equals. Like, you have to be able to treat everyone equally. That's just a very basic point. I think that's kind of inherently what you need to be, and that's what every lawyer should have anyway, in my opinion. So I'm not sure there's anything specifically inherent, except possibly to say it's better if you are able to read yourself. As I said before, that's something that's if you have that inherently, then you might find it much easier to maintain that balance.
Thank you. George, anything to contribute to that?
I don't think so. I think it just comes back to this personability point. It's that really humanizing a personability point, but ensuring that you kind of don't digress into informalities or kind of like colloquialisms. I think it's really important just to people always say you have to often find yourself first before you can kind of give yourself to other people, and I think that really resonates to this particular situation. But also understand that sometimes, going back to this kind of self-care piece and looking after yourself piece, sometimes the way you are on a day is different. So don't be hard on yourself if, for example, you feel like you haven't presented yourself in the best light in an interview, or you haven't been the best version of yourself, because there's plenty of opportunity to do that in the future. Sometimes you won't be able to deliver the best presence of yourself. So just don't be too hard on yourself, and just try again and try better for the next time.
Perfect. Thank you. And Samia, really quickly.
I think it would go back to the emotional intelligence, and to add to that would be resilience. I think absolutely this job needs resilience, and just to kind of sometimes really dig deep when you need to, but then on the flip side, also know when to walk away, which goes back to what George was saying about knowing yourself. I think that's what it comes down to.
Thank you so much. And so finally, just really quickly, any specific tips or takeaways for people watching today? So George, maybe first.
Yeah, the takeaway tip I would say is just practice makes perfect. Similar to anything that you do in life, I think the more you kind of expose yourself and practice interviewing, starting with family and friends, or potentially, with clients, attending pro bono clinics, shadowing people, the more exposure you get to it, the more comfortable you feel. And don't worry if you haven't got that confidence at first; it will develop in time.
Perfect. Thank you so much. Josie.
I was going to say something very similar. So echo what's just been said. I think really think about every situation that you are finding yourself in. I've given the example of, being at the hearing or just before the hearing. Really think about all those things beforehand. You have to prepare. There's lots of things that you won't be able to do on the day, like get an interpreter, or I don't know if there's any accessibility issues. Those are things that need to be thought of in advance. So making sure that you prepare and think about all of these things is really important. I spoke at the beginning about ensuring your environment is the best that it can be, and that takes that beforehand thinking. So yes, preparing, I would say.
Perfect. Thank you so much. And obviously we heard Samia's helpful tips already. So I think that's it, and that's almost time anyway. So thank you so much to our panel for sharing all their thoughts on this hopefully really important topic for lawyers and for everyone watching. I hope everyone found it really helpful and informative. We're really grateful to the panel for joining us. Thank you so much, and to everyone who watched. So I'm now delighted to hand over to Louis Asquith, who is Vice Chair of the Human Rights Lawyers Association and an Associate Solicitor at Russell Cook. She will be chairing session 5 today, which is about emerging human rights challenges and their implications for future legal practice. So thank you so much, everyone. And Louis, over to you and to our speakers. Thank you.
Thank you very much, Shoaib. Okay, speakers, if you want to emerge, fantastic. Hi, everybody. I'm Louis Asquith. My pronouns are they, them. I'm a lawyer at Russell Cook, LLP, and co-vice chair of the HRLA, and it's a real pleasure to be here. And we've got all our panelists, which is fantastic. So we're moving on from client interviewing to discuss emerging human rights challenges and implications for future legal practice. So we're all aware that there are evolving sort of societal, technological, environmental shifts. So we're going to have a conversation by considering some of those areas and consider these sort of emerging areas of challenge that are arising, continuing to arise in some instances, and its implication on practice. What we'll do before we get into the detail is introduce our fantastic panelists. So we're going to ask each panelist to give a couple of minutes descriptions to how they got to where they are today, noting that the audience are, or many of whom may be looking to get into the human rights profession. So if you can be kind enough to offer, as I say, a bit of your story to those listening, that'd be fantastic. And then thereafter we'll move on to some questions. Okay, I'll start with Dr. Deborah Long.
Sure, thank you. Yes, so my background really is that I did do my training as a solicitor and worked for a short time as a personal injury lawyer before then doing a master's in international human rights law. And that's many years ago now. And since then, I've actually worked mainly for NGOs. So after doing my master's in international law, I did an internship with an organization over in Geneva just to get a bit more experience, really. And whilst I was there, at the end of that internship, I was very lucky to be then given a permanent job there. So, and then I sort of worked my way through and became head of the UN and legal program there. And then I've worked in various NGOs since then. I'm now the international policy manager for rule of law and human rights at the Law Society, and I'll be saying a little bit more about what we do there. Maybe a couple of top tips I think I've found. It obviously is a very competitive environment, but I've also I've sort of found my way through by trying to see any opportunities that are there. I think some of the big, if you want to work for an organization such as Amnesty International, there can be quite closed shops. So actually some of the smaller NGOs, for example, may have opportunities. But also one good thing is there's lots of different entry points to doing human rights. You can do it through NGOs, you can do it through law practice, you can do it through academic centers, whole range of things, and also with government institutions as well. So the good news is there's lots of entry points, but there's also, unfortunately, no, I guess, obvious one route. But I'm very happy also to answer questions around anything to do with my career so far. Thank you.
Thank you very much. Yeah, and I should say, please don't hesitate in starting to ask any questions that you might have. We can hopefully approach this with a conversational, approach it with as a conversation rather than a robotic. I ask a question and one of our panelists responds, so please don't be shy. Okay, Dr. Felicity Jerry Casey.
Hi, it's Felicity Gerry actually. Hello everyone. I am a silk in England and Australia, and I also practice in a couple of the international criminal courts. I think as a result of working internationally, I've been approached to do some really unusual things, including cases on historic reparations, reparations for historic slavery in the Cook Islands, claims for deforestation in Papua New Guinea, a petition for mercy for a young Indigenous man in Australia, and I was briefed to represent the organisers of the Black Lives Matter March in Victoria in Australia during COVID, as well as lots of issues that arise in crime that have human rights overlaps. So I thought I'd talk about most of those today. A lot of people will know me mostly for criminal law, but I actually have a really unusual practice. And one of my favourite stories is some administrative law in relation to the first piece of land that was handed back to the Larrakia people in the Northern Territory of Australia. So if anybody wants to ask me about any of those, I'm happy to talk about my human rights / environmental climate change cases.
And did that happen organically? Did sort of that expansion in practice? So, Felicity, how
I
did
made
that...
myself. I decided I was going to be an international barrister,
Yeah.
and the last one, the Larrakia people one, the solicitor said it's Australian language, but they said we wanted a gun lawyer. They meant someone who would stand up and shout for the Larrakia people, and I think that might be my reputation.
That was you.
So.
Excellent. Thank you so much. Vicky, we'll come over to you.
Hello, everybody. So my name is Vicky Praise. I call myself a lawyer plus now, actually, because I'm a lawyer plus many other things. So I'm a lawyer plus an independent human rights consultant, plus a human rights career coach, plus a researcher, plus a sometimes speechwriter. So, but at heart, I'm a human rights lawyer. My career path has neither been sort of by design or planning. I've taken every opportunity that's come my way, but I suppose I've touched every bit of the human rights world, ranging from international organizations. I was a staffer at the Council of Europe for a couple of years, and then was with the UN in Kosovo, cut my teeth as an immigration and asylum lawyer for a big national charity here in London, which was a very sobering experience, but was a great training ground for the work that I've gone on to do. To the not-for-profit sector, working for Penal Reform International, Amnesty. So kind of had lots of different experiences. My area is prisoners' rights, prison reform, and dignity behind bars, and that's been a constant theme through my work and through my practice, to where I am now out on my own as a bit like Felicity, a hired gun, basically, so whoever will kind of instruct me. So last week I was in Albania training prison officers on international human rights law. So that's a little of me, and very happy to answer any questions thereafter.
Excellent, thanks, Vicky. And last but not least, Haj.
Thanks so much, Louis, and thank you to the organisers for inviting me to be on the panel today. So yeah, it sounds like I've got a kind of similarly diffuse journey to the rest of the panel. I'm, as you can probably tell, Australian, so I qualified as a solicitor in Australia earlier in my career, and I worked in a range of different areas, firstly at the Environmental Defender's Office, and then I, like Felicity, worked in native title and Indigenous law in the Torres Strait Islands, which is a band of islands in the northern part of Australia, between mainland Australia and Papua New Guinea. And then I worked as a refugee lawyer in Papua New Guinea and in one of Australia's offshore processing centres called Manus Island. So I came over to the UK almost 10 years ago now to study, and did a law master's and a policy master's. And that was when I decided to focus on climate law and litigation, which is predominantly what I specialise in these days. So I'm at Doughty Street. I work in our climate and environmental justice team. I helped set that up when I joined Chambers a few years ago. And my practice is mostly international. So I've been working in across these advisory opinions, which I'll come into a little bit later, and on human rights law at the European Court of Human Rights, Inter-American Court of Human Rights, and a few transnational environmental law matters. So yeah, very happy to be here today and looking forward to the panel.
Fantastic. And before we kick off with our specific questions, I just wondered, Deborah, would you just tell the audience a little bit more about sort of your day-to-day? Policy work is obviously I often think it runs in parallel often with legal practice. And policy is a term that's often kind of bandied around. And I'm conscious that some people in the audience might want to understand the nature of it, but specifically relative to what you do, just to provide that extra context before we dive in.
Yeah, absolutely. I mean, I'm lucky, really. The role that I've got at the Law Society is really quite diverse. So I'm part of a small team of 3 of us who work on international human rights issues for the Law Society of England and Wales. And we have 2 main programs for that. One is our Lawyers at Risk program, where we do all sorts of different interventions on behalf of lawyers anywhere in the world who face interference and human rights violations because of the work that they do. So the lawyers we support don't have to have any link to the Law Society. We speak up on behalf of any lawyers. So we do different things. So we can do intervention letters, we do reports to the UN, and we engage with governments around the world. We also, of course, engage with UK government and MPs around that to try and encourage them to speak up, but also for their foreign policy to be supportive of lawyers and the role that they play in society. The other program is a sort of peer engagement and capacity building program, and that's where we try and interact with our peers in other countries, could be other lawyers, law societies, bar associations, and they're trying to share good practice around the protection of lawyers. We also try and we do some training of how to engage, for example, in UN or other human rights mechanisms, and really try and kind of create a sense of solidarity, really, and community where we can share information, good practice. And in terms of the Law Society itself does lots of different things for our members, lots of policy work for our members in terms of guidance, how to work, practice notes, things like that. And our, I guess, policy work comes in through